specifications for a threshold keyed to the relative size of the zone rather than to the relative use of the facility. So the court's comparing PJM's test to an alternative that more closely tracks the regulatory goals. And if you apply that approach here, I think even if you were to think in a vacuum, the $5 million threshold sort of roughly tracked which projects are most likely to progress through the queue. We don't know if it's unduly discriminatory until we look at whether there's an alternative. And Hecate's minor tweak to that $5 million cap would more accurately identify projects that would get through the interconnection process. Because
can you just articulate for us what you envision would be the minor tweak? What would be the rule that the distinguishing line that they would draw?
Yes, Hecate's proposal was if a project is assigned above $5 million in network upgrade costs, then it could enter the expedited process so long as the sponsor of the project, Hecate in this case, is willing to put up the $5 million or more itself to guarantee that it would pay that amount rather than squabble over how the costs are allocated. And that would guarantee, number one, it would guarantee that the project has financing, which is a major reason.
Put up the more than $5 million.
Correct. Correct. Yes.
Put up the whole cost.
It would put up the whole cost that was assigned to it, which in this case is everything above 5 million or above, whatever that amount would be. So that clears up the financing problem, which causes a lot of projects to drop out of the queue because they've got their finance.
Pay-to-pay scheme, because it wasn't just that; it was also that the 5 million or less projects are supposedly less complicated and will require less study.
Yes, so I think there's one major problem. There's two major problems with that. Number one is the substantial evidence point, which is just PJM is just telling us that. They have no data to back that up. And that's in the face of industry commenters who said, no, that's just not the case. The amount of network upgrade costs does not determine how complicated the studies are, because if you've got one party that's willing to foot the bill, there's not going to be a lot of complicated studies about who gets allocated what. I think the second problem with that is that we have alternatives that keep the $5 million cap. So even if you think the $5 million cap has some value in weeding out more complicated projects, then we've got the cure for that we presented to FERC, which is if it's over $5 million and you got a company willing to foot all of those costs, that makes those just as likely, if not more likely, than the ones below 5 million to get quickly through the process.
What do we do with that? Over 80% of the stakeholders approved this project.
And only 30% favored the rule that you're proposing.
Well, I think this court reviews the commission's order and the commission's reasoning. I'm not aware, and I don't think my friends have cited any case where the court sort of applies doesn't have to be, it can be a little more arbitrary because a lot of stakeholders approved it, or it can be a little more discriminatory. I just don't think that's practically the way this court reviews rulemakings.
You got FERC's sworn statements and PJM's experience balanced together and stakeholders.
So, Your Honor, I'm not at all disputing that PJM's experience could have value. Of course it could. If it had come in and said, look, we've got all of this data that tells us how quickly projects progress through the queue and when they drop out. And here's the ones above 5 million, there's 50 and 30 of them dropped out. Here's the ones below 5 million, 40 out of 50 made it through. Well, we'd have a much harder case. I'd be having a much harder time making this argument. But they didn't do that. They just said, in our experience, this. And then when they came down to give actual data, as Judge Henderson pointed out, all they said was a majority of projects above 5 million drop out. But they didn't tell us whether a majority or a minority or whatever the percentage is of projects below 5 million drop out. So that doesn't tell us anything about whether that's a good dividing line.
Okay. I do want to ask one thing, and I'm not minimizing your position, but if the expedited process is due to expire in January of 2025, and you've said, I think, that if you're not in the expedited process, it'll be 2026. Are we just talking about a year's delay? I know that can mean a lot, but is that what we're basically talking about?
Well, I think you're right to say that can mean a lot, and that's certainly enough to show redressability and standing. I would say we're talking about at least that amount, and I think it's important to remember that PJM has under-projected things many times in the past, to say the least, with respect to the timelines. And so right now they're telling us those dates. I'm not impugning that or doubting that. I'm just saying that's what they're currently telling us. And we would much rather be in the expedited process that does look more firmly like it's set for a particular end
This
date.
whole transition period ends when? 2027?
Well, I don't know. I don't know. I think they're saying that transition cycle number one, and I'm going outside the record. Okay.
I'll ask them.
Yeah, I mean, I think in the rehearing order, FERC said that transition cycle number one was set to conclude in early 2026.
Okay.
And then just the Honeywell case that does allow the agency to rely on representations for those uniquely qualified to provide that information. Do you have anything to say against that?
Nothing to say against it, certainly precedent of this court. But I think the difference there is what they said were facts that could be verified and tested. And here we don't have access to all the data that PJM has. The commission is well known for requesting data to be able to evaluate the assertions of a utility, but it didn't do that here. It could have asked PJM for that data about projects above 5 million and below 5 million in order to test it. And then I think Judge Childs, the most revealing part to me is what I was mentioning to Judge Henderson. When you look at the specifics of what they think illustrates their experience, it's a majority above 5 million drop out. The other thing that PJM mentions, I think they mentioned it in their proposal. I'm not sure the commission relied on it, but they also relied on the fact that of the total amount of projects, only 10% are assigned network upgrades over $5 million. But that just tells us that projects with that type of network upgrades are rare. It doesn't tell us how many of those proceed to completion vis-a-vis how many projects with network upgrades under 5 million proceed to completion.
All right, we'll give you a couple minutes in reply.
Thank you.
Al?
May it please the court, Angela Gao for the commission. I wanted to start where we left off with redressability. FERC, as your honors mentioned, would necessarily have to reject the proposal in its entirety on remand, and it's completely speculative that Hecate would get the ultimate relief that it wants. It hypothesizes that once FERC rejects the proposal, PJM will submit a new 205 proposal. But even assuming that PJM does, as Judge Childs mentioned, who knows what that proposal would look like? It could entirely eliminate the expedited process. It could use a different threshold that still somehow excludes Hecate's project, or it could narrow the expedited process as well. The point is, all of this is simply guesswork. And that's not enough for redressability. Hecate has to show that it's likely, rather than just merely speculative, that its injuries will be redressed.
What about Mr. Street's concern that it's one thing to rely on PJM's expertise, another thing to rely on PJM's expertise when it gives only one side of a comparison? Bigger projects drop out. Do we know the rate of dropping out of below 5 million projects? And if not, does that concern FERC? And why, if not, why not?
Well, I'd want to point out first that the $5 million threshold has a proven track record. It was historically used since 2008 for a very similar purpose as it's used here, which is to identify network upgrades that have significant costs and have more complicated cost allocation issues and would take a longer time to process. So PJM's statements, they're actually empirical observations based on their 30+ years of experience in processing these interconnection requests. They're also not just theoretical. They are observations that PJM has made that projects with below cap upgrades are fairly straightforward and simple to process, whereas projects with above cap upgrades are more complex and time consuming. And with regard to the point that there needs to be a comparative value to balance statements against, I think that goes more towards Hecate's point that the commission didn't address certain alternatives in its analysis, and that's unnecessary in a Section 205 proceeding. In Section 205, FERC is required to limit its inquiry to the confined proposal at hand, and it's not allowed to move on to alternatives that PJM itself didn't propose.
Scott, can you explain what the logic is of saying that more complex and likely to drop out projects or proposals would benefit from the cluster-based approach, whereas simpler projects that are more likely to proceed wouldn't? Just a little bit more sort of just concrete understanding of the cluster-based approach and why it's particularly appropriate to the larger project.
Sure. Above cap projects, they have costlier network upgrades and therefore more significant impacts on the grid. These projects have complex studies and cost allocation issues. You can imagine the larger a network upgrade is, the more projects are going to be responsible for sharing the costs of that project. And the task of dividing up who pays how much is one that's often hotly debated and more time consuming to get through. Also, these projects just inherently take more time to process due to the cost allocation issues, as well as the more complicated studies that they require. And because of these costly network upgrades, they're also at higher risk of withdrawing from the queue and triggering the need for restudies. So
all of that seems to sidestep Hecate's position, which is there's no study about who pays if we're going to pay for the whole thing. What is missing there? Is it, I mean, I take it that the ISO system doesn't just exempt from planning transmission upgrade projects that would be fully paid, or does it? And if it does that mean that there's never any cost passed on? Like, it's just a little hard,
I understand.
to appreciate, given what Hecate is arguing about its willingness to carry the costs, if the complexity that you're describing is about cost allocation.
My understanding of Hecate's alternative is that it's proposing to cover its share of the cost of a network upgrade that's over $5 million. But that doesn't guarantee that other projects that are also responsible for the same network upgrade are going to fork over the money. And the longer that process draws out over who is responsible for paying what, that just contributes to the delay in already existing backlog in PJM's interconnection system. So this is why projects that are simpler, easier to process, or what you could consider as clean projects, they have minimal impact on the grid, very little, if any, network upgrades required, and can be studied and completed very quickly. That's why they're more suited for the expedited process, which still uses the legacy rules serial cost allocation procedures. Those are the procedures in which, if a project decides to withdraw because it feels that the costs are too high, that would be extremely disruptive and trigger iterative restudies for the remaining projects in the queue. Now, for projects that are more complicated, above $5 million, it makes sense that they're being allocated to this cluster-based system because it's been improved to withstand a lot of the drawbacks under the legacy rules. It discourages late-stage withdrawals and also minimizes their disruption to the remaining projects. By studying all the projects together, it makes the process much more efficient. So it's reasonable that the threshold pairs inefficient serial rules with below cap projects that are low risk with simple cost allocations, while also pairing the improved cluster-based rules in transition cycle 1 with the above cap projects that are more complex and have a higher risk of withdrawal.
So if you've got data that's showing that less than 10% of your projects with the network upgrade costs are exceeding the 5 million lead to project completion, is your concern more about the queue or achieving a higher rate of interconnection?
So I would say it's both. The broader goal of interconnection reform is to get more generators on the market, which means more completed interconnection projects. But the goals of this specific reform filing by PJM is to deal with the incredible backlog that it has in its interconnection queue right now. And that has to balance two competing goals. The first is to transition as quickly as possible to this efficient cluster-based system and procedures. And the second is the need to respect the priority to the extent possible of older projects that are already in the existing queue. So the expedited process, by identifying projects that PJM believes, based on their 30+ years of experience, are clean, easy, fast to process, it can get through the backlog quicker and move towards that transition faster.
Can you help me understand in this case whether there's a meaningful difference between the factors and analysis that goes to unduly discriminatory and the factors and analysis that go to just and reasonable? It sort of seems like maybe it's all one and the same as applied here.
So I believe there's substantial overlap. I can't say for a certain matter whether they're completely coextensive, but it's true that under Section 205 in the just and reasonable standard, FERC only needs to find that the proposal fits within a zone of reasonableness. And that means that the proposal doesn't have to be the least discriminatory option. It doesn't have to be less discriminatory than what Hecate's proposing or other alternatives. It just has to be not unduly discriminatory within that zone of reasonableness. And that's exactly why, as the Commission explained, it didn't need to proceed to continue evaluating alternatives after it had already found that PJM's proposal was just and reasonable under Section 205.
So if there's a valid reason for treating projects below and above the 5 million threshold differently, does that, in your view of the law, that would resolve just and reasonable, but wouldn't it also resolve unduly discriminatory?
Yes, I believe that's correct. The threshold is only unduly discriminatory if it treats similarly situated projects differently for no discernible reason. But here there is a discernible reason, and as more of a fundamental matter, these projects are not similarly situated. As we've discussed, projects above and below the threshold are vastly different in terms of how quickly and easily PJM can get through them in the interconnection queue. I'll also mention the examples and hypotheticals that Hecate has come up with in its brief. That's just the natural consequence of having a cutoff. There's no perfect administrative line drawing, no perfect classifications. And that's okay under Section 205 because, once again, FERC doesn't need to approve the least discriminatory option or one that's less discriminatory than other alternatives, so long as what it has approved is not unduly discriminatory and is within the zone of reasonableness. And I think cities of Bethany—
Just to help me out, can you give an example of a case in which something is just and reasonable, but nonetheless unduly discriminatory? I'm just trying to—
I actually do not know of a case. I believe that there is significant overlap. I don't know if I could say for certain that they're completely coextensive, but I believe that if the proposal is just and reasonable, then I can't think of a case where it was somehow unduly discriminatory.
All right, I do want to ask you one question. Do you anticipate making your target date of January 2025 on the expedited process?
I believe that PJM is on track to meet that target date. And I'm glad that you brought that up because it comes back to the point that, at this stage, we can't turn back time. The expedited process, it's already been ongoing for several months and is by PJM's latest updates that have been filed in the FERC docket and also posted publicly on its website, on track to be finished by, at the latest, January 2025. Most projects in the expedited process are actually in the last stage, which is negotiating their interconnection service agreements. So because the expedited process will soon be over, it's unclear how Hecate would achieve its ultimate relief of entering its project into that process when it will no longer exist in a few months.
And quickly, do the transition cycle matters, do they absorb higher cost by being studied in the cluster versus the serial allocation?
So I don't think we can say that. This cost allocations are different, but I don't know, the methods are different, but I don't know, how that impacts the resulting costs. And perhaps PJM can speak more to that. But I will also say the alleged, or the injury that Hecate is alleged is not any difference in cost allocation methods. It's the delay that they say that their project is suffering, which, absent these reforms that led to the $5 million threshold, its project would most likely be even worse off in the queue. So the fact that Hecate hasn't, sought to expedite, its appeal in any way is telling. I also want to return to the substantial evidence point. This court has previously rejected arguments that FERC's determination is unsupported simply because it lacks what some may call actual evidence. And that's in, for example, Aenergy, where this court explained that it's perfectly legitimate for FERC to rely on generic factual predictions and base its findings on basic economic theory. In that case, FERC was not obligated to show actual evidence to support its determination when it was simply making the kind of reasonable prediction about the market it regulates to which courts ordinarily defer. And here, that's reinforced by the fact that the $5 million is, again, as mentioned, a historical metric that PJM has used to successfully identify projects that are more complicated and time-consuming. And it demonstrates to the Commission that this threshold used in this context of PJM's latest reforms would also most likely be effective for that purpose while being just and reasonable and not unduly discriminatory. And finally, I'd like to return to a point that Judge Childs had raised about the lengthy stakeholder process. It's completely correct that this package of reforms was carefully constructed through a very extensive stakeholder process in which stakeholders were shown, different alternative proposals, and it was the $5 million threshold that won overwhelming stakeholder support. It was a very carefully negotiated key component of the proposal. Hecate is essentially trying to do an end run around this process in direct opposition to the goals of interconnection reform in Order 2003 and also the 2008 Interconnection Order. In both of those orders, the Commission emphasized that independent operators like PJM need to be given flexibility to shape their interconnection procedures in the ways that best address their regional needs. And instead of imposing any general rules or procedures that all operators had to follow, it wanted operators to engage in the stakeholder process and work with its constituents to find the best possible solution.
I had just one question of, frankly, something that confused me, and your expertise might help me walk it through. In the Commission's explanation of its denial of Hecate's request, and I'm looking at JA 605, it's paragraph 30, the Commission says that the 5 million threshold is not discriminatory because removing requests that cause a relatively low level of network upgrades, quote, should marginally improve the processing of the remaining transition interconnection customers by reducing the total number of interconnection requests in the transition serial and cluster studies, thus marginally reducing both their complexity and the total number of entities that might withdraw during the transition process and trigger the need for restudy. So this is saying you take out the simpler requests and process them first. That's going to speed up the processing of more complex requests. And why does that speed them up? It seems clear that it would speed up the processing of the simpler requests, but then is it also the cluster studies? Is the efficiency?
So it speeds them up in two ways. First, by getting rid of the easier projects and finishing them quickly and first, that in turn improves the processing of the remaining projects by reducing the total number of projects that still are left in the backlog. And
Except by putting them later. Go ahead. You have a
Right.
separate queue for them. Go ahead.
in a separate queue, but still fewer number of projects in that queue reduces the complexity because there's fewer project interactions, fewer cost allocation disputes. And second, it reduces, the likelihood of withdrawal and restudy for the projects that remain when you make the process simpler and limit the number of projects that remain to be studied.
Isn't that because, or at least FERC's reasoning, that's because of the cluster approach, the additional cluster approach for the more complex programs?
It's partially based on the cluster-based rules that do make processing these projects more efficient and can resolve some of the concerns, but it's also by virtue of just narrowing down the projects that are left.
Right. So the passage says that removing the requests and putting them in the expedited queue will, quote, reduce the total number of interconnection requests in the transition serial and cluster studies. The transition serial is the expedited
process.
and the cluster studies are, and
Transition cycle one.
cycles 1 and 2 both use the cluster base.
That's correct.
So the transition serial is the expedited queue.
Yes, that's correct. And I think there, the commission's actually referring to a comparison to, a situation in which PJM could have just omitted having an expedited process altogether. And then you can imagine the groups for each transition cluster would have included a greater number of projects within them, increasing their complexity and increasing the risk of withdrawal and restudy.
So really the 5 million threshold is sorting where do we apply cluster based and where do we not?
I believe, yes, from the projects that were in older queue windows, it's just trying to determine which projects are faster and easier to process using a serial process versus those that are more complicated and should be reserved for using in the cluster process.
Great, that's helpful too.
Right, thank you.
Thank you.
Ms. Warren?
Good morning. Wendy Warren for PJM Interconnection LLC. May it please the court, I'd like to start right where Judge Pillard left off because you hit it on the head. The entire point of the expedited process. So let me back up. Recall that this is all about moving from a serial process, which means we study one project, then we move to the next project, then we move to the next project. We study them in a serial fashion, we allocate the costs in a serial fashion. And that was very slow. The proposal was to move to the cluster-based, and there's two things about clusters. You do one study. If you've got 300 projects, you do one study. Well, you do it 3 times, but you do one study.
Tell us just a little more.
Okay.
What is being studied and how can you get away with one study? How does that compare with what happened in the past?
So the first step is you build a model of all the transmission lines that are already there.
Be even a little more general than that.
Okay.
You're studying
in the first round is system impact, which is this generator, if I interconnect it here, And I'm not an electrical engineer, so I'll be really simple. If I plug this generator in
Luckily,
here-
I am, so.
Oh, good. Maybe you can explain it. So if you plug it in here, what reinforcements do I need to make around it? Do I need to upgrade, make this line carry more power? Do I need to put another circuit breaker here? So that's what we're talking about when we talk about network upgrades, is the reinforcements that we need to make to plug that generator in. If so you build your model of everything, and then in the serial study, you start with load flow. What does that generator plugging in there, and you build the whole model, but you look at just that generator. What does their project do to the flows of electricity on the system? And how much is it going to cost? Or, what's the impact? What do we need to build? The second round of the system impact study, this is now in the current process, but it was true in the old one. You start looking at really more detailed things like short circuit and stability of the system. And you don't necessarily have to study that for every project, because some projects don't cause those problems. The last study is a facilities study, which is where the transmission owner that they're plugging into tells them how much it's going to cost exactly. I mean, everything before is just kind of an estimate. Now we're getting down to, dollars and cents and specific equipment. So
You're talking about how much the upgrade will cost.
how much the upgrade will cost. And so when PJM was talking about, we're meeting with the stakeholders, talking about, we're going to go from this really slow, inefficient serial process to this new process where we put everybody together. We do that load flow study one time. We have a model with everybody in it and we run it once.
So how do you cluster? That seems like that becomes the really key thing. And
You cluster by time.
Time of.
You open an
proposal?
application window. You say, we will be taking applications. Right now, PJM is taking applications for transition cycle number 2. And that window ends in December. And then we will know how many projects are in transition cycle number 2.
So it's not, it's geographic to the extent that PJM is geographic. but
Right.
It's just all the things that are on the table as possibly going to be done. Let's look at them all together
Right.
and figure out, if we were going to do them all, how they interact,
How they interact,
what they require.
what we need to do to reinforce the system. And so, but here's the second part about clustering. Instead of saying project 1, your network upgrade costs are $4 million. Project 2, your network upgrade costs are $3 million. You just lump it all together. You studied everyone together, and you say the cost of the upgrades for this 300 projects is going to be, $5 billion. And they each take a share of that. So you eliminate a lot of the things Mr. Street was talking about, the haggling, the projects dropping out because their costs are too high. Okay, but now.
So in that sense, it recognizes that there's not one simple cause, that things are interactive. And therefore, if you're doing this serial, you're losing all kinds of things. You're losing efficiencies. You're also losing externalities that may be associated with each proposal. So when you put them all together and kind of look at it all and say, if we were to do all of this, what would be the cost and how would it be fair to allocate them?
Right. But so now imagine you're a stakeholder, you're meeting with PJM and your fellow stakeholders, and you have a project that has been under study for 2 or 3 years, and you know what your network upgrades cost, and they're low. You're only responsible for $1 million in network upgrade costs. And so you say, I don't want to go into that transition process. I don't want to go to the new process because I'm going to have to pick up a share of everybody else's costs. I like what I'm hearing right now. I like serial for this project. And so this was the goal of the expedited process, was there were projects out there, they'd already been studied, they knew they were below, we knew the network upgrades were below $5 million. So they were simple. We could do it quickly because they'd already been studied. And it was more a matter of cleaning out, we've got a backlog of, and I think it was at least 1,500 projects. We had a backlog. What can we get out quickly?
And are they're almost done? They're getting close to.
They're almost done and they'll be done by December.
So here's my question. When Hecate says, look, we'll pay our portion, I'm imagining, well, maybe that creates distortions if you imagine that as compared to the cluster system, where the cluster system is saying, well, maybe what you're being asked to pay for is a different actual physical infrastructural solution than what would be chosen as a result of a cluster study for all the interconnections. Is that part of the issue or not really?
That may be part. I can't speculate as to what Hecate's interest is exactly.
But I'm thinking more of what's PJM's interest in the sense of, well, why wouldn't you have 5 million threshold asterisk unless you're willing to just be assessed and pay whatever we ask you?
So the goal of the 5 million was to identify projects that were almost done,
right,
and could be done quickly. That was the key metric, or that was a key metric. The asterisk will pay. I was interested to hear petitioner talk about the worry was dropping out. That was not the worry. The worry was these projects are almost done. They're not dropping out. They have low network upgrade costs. They want to get this done. And they want to get it done quickly. And so let's get them. It wasn't even, yes, it was getting projects out of the transition cycle clusters, but it was really, they're almost done. Let's get them, clean up, get them done, and then we can move on to the transition cycle. And by the way, and this I think is really critical, some of the questions you were asking and the answers were not correct. If the court were to decide that this $5 million threshold is unjust and unreasonable, unduly discriminatory, if it goes back to FERC, if FERC, well, one possibility is we have to start all over. And it's not guaranteed that at that point PJM would do an expedited process because, well, we'll get into that in a minute, but it's not guaranteed that we would do it because at this point we're 3 years on.
And almost done with that's going to phase out and everything's going to be by clusters?
Yes, this is the last serial cluster, and it was the last serial cluster because the people in it liked it. Or last serial queue.
Thank you.
Queue, sorry. But, oh no, but that's critical because the only thing that was serial about it is the cost allocation. They are only paying their own costs. They're not spreading it across the cluster. They were studied as a cluster. That took place last year or early this year. The expedited process started July of 2023. And at that point, there was a single study. If, as Mr. Street said, let's just put Hecate and a couple of their friends back in. We'd have to go back and redo the entire expedited process study. People who currently have, either they've currently finished all their studies, they're only waiting for one study, or they might even have an interconnection agreement that's on file with the commission. We'd have to throw that all out. Let's start over again. And what that would do would be to delay the expedited process, certainly, which would push back TC1, which would push back TC2, which would push back the eventual arrival at the new process, which is all we really wanted to get to in the first place.
I have a kind of unrelated question, which is the relationship between stakeholder support and PJM's authorities. Could PJM submit to FERC proposed reforms that are approved by only a third of its stakeholders?
I don't think it can. I don't think I've seen that. The board of PJM can decide to file something, even if that was not the option chosen by the stakeholders.
And what limits that? What controls PJM's?
It depends what
Autonomy.
area of the tariff we're talking about. If it's, for example, transmission rates, that implicates certain rights of the owners of the transmission assets to file changes to those. PJM can't change that. If it's interconnection planning, and that's within
PJM
PJM's
has
205
more autonomy
authority.
there.
Yeah.
Just quickly, with respect to the transition 1 cycle and the transition 2 cycle, if a generator drops out,
Mhm.
explain that process of how the costs are absorbed at that time.
So transition cycle 1 and 2 they're done by phase, and all the future under the new rules, it's 3 phases. And for example, transition cycle 1 just finished, just passed through phase 1, which was they did a system impact study that looked at all the load flows for the whole cluster, and then said, here's what we're looking at for everybody. Do you want to move forward? If you want to move forward, you need to give us some technical specifications on your equipment. You need to put down a certain study deposit. You need to put down kind of earnest money. They're called readiness payments.
What I'm really trying to get at is, will Hecate absorb costs for the generators that drop out?
Everybody who stays in the cluster could absorb costs, but the readiness payments that I had just started mentioning, those protect the people who stay in against the people who withdraw. So as you move through the phases, you have to put up more and more money, more earnest money, more skin in the game. The later you drop out, the more money you leave in the pot to help build all the things for the entire group.
This is under the new system.
That's under the new system and the 2 transition cycles.
In terms of redressability, I thought you might have said that you had 2 points of what would happen if this were remanded to the commission, and I'm not sure you got to.
So, well, the other one was and I slipped it in, but the real problem here is we can't just put Hecate back in and finish up. We've got, 300 projects that are almost done. If we add Hecate in, everybody has to go back to the beginning.
All right, thank you.
Thank you.
All right. Mr. Street, why don't you take 2 minutes?
Thank you, Your Honor. There's a lot to respond to there. With the court's indulgence, I'll try to briefly hit 4 points. First, FERC trying to articulate a basis for the $5 million threshold says that there was a track record for that threshold, and they asserted that it was previously used to identify more complicated projects. That is not in the orders at all, and that's not accurate. The $5 million threshold was used to determine whether the costs could be allocated across different queue windows under the old process. Had nothing to do with whether the projects were more likely to be complicated, more likely to proceed to completion, or more likely to clog up the queue. So they're really arguing, well, we used $5 million for apples over here, so therefore it makes a lot of sense to use $5 million for oranges over here. The commission also argued that the $5 million threshold identified projects that would have more complicated cost allocations, but I didn't hear a persuasive answer for why if a company is willing to pay all of the network upgrades that are assigned to it, that doesn't solve those complicated cost allocation problems. And the real key, I guess, is FERC didn't address Hecate's argument in that respect in its order. It's made attorney argument this morning about why Hecate's proposal to pay all of the cost allocations somehow doesn't solve the complicated cost allocation problems, but that's not in the order. And that's why the commission has to grapple with alternatives to determine whether something is unduly discriminatory. So let me turn to that in some of Judge Pillard's questions about how discriminatory can something be, how much is the overlap with just and reasonableness. The commission is citing, and PJM is citing cases in its brief that say in just and reasonable cases, the commission cannot select some other alternative. But our point is that in an undue discrimination case, you don't know whether something is unduly discriminatory unless you compare it to the available alternatives. You won't find a case that says in an undue discrimination case, the commission doesn't have to look at alternatives. They would have cited that, it would have been on page 1 of their brief. In fact, what we have relied on to this court is the consolidated Edison case, pages 282 to 283. I come back to that again because that was an undue discrimination case. The court didn't just say something was just or reasonable. It looked at whether the dividing line or the test closely tracked the regulatory objectives. And when the court found that there was some alternative that directly tracked the regulatory objectives, it vacated the commission for failing to look at that. So I think the key with undue discrimination is, is it pointless discrimination, right? Is there something else out there that's readily available that the commission could look at? And at a bare minimum, I would say, even if the failure to look at alternatives doesn't substantively undermine, directly require vacatur of the $5 million threshold, at least administrative law 101 is the commission has to respond to major comments and major objections to their approach. And they say in the background of their order, Hecate and the other commenters made these proposals. And then when they get to the reasoning of their order, they don't say anything about them. So I think we're exactly in the situation that we were in the California Public Utilities Commission case from 2021 that I believe Judge Henderson authored, where you have no substantial evidence for the central test that the commission used. You've got commenters pointing out, hey, there's these other options, there's no evidence, and the commission is just silent in the face of that objection. Finally, I want to turn back to a remedy. I think the argument that the commission would have to throw everything out that it approved, it would just have to completely vacate everything, is just completely contrary to consolidated Edison. That was, again, involving network upgrade costs. There were 6 or 7 challenges. The court accepted 2 or 3 of them, and it vacated only as to those 2 or 3 unduly discriminatory tests. And there's no reason to think the commission, therefore, is going to throw out the entire order. Now, turning to PJM's argument that maybe they will throw out the entire expedited process. There's no way they can make an accommodation for Hecate. I guess the number one thing I would have to say to that is that's attorney argument this morning. That's not even in their brief. I mean, PJM didn't even argue lack of redressability. The commission did, but it didn't argue about this impossibility of giving Hecate relief. It was more about having to go back to the stakeholders. So I think that based on the record that the court has, there is going to be a period of time where Hecate could be accommodated. And at the very least, Hecate is entitled to a remand or a remand with vacatur for the commission to do its job.
Is Hecate in a class of 1? I mean, if PJM were to propose a rule, supplemental rule, it sounds like you're asking for, that would say, the serial treatment transition rule should also apply to self-funding projects. And maybe there's some other way to define largeness or complexity other than cost. I don't know. But if they just were to say self-funding projects should also be in a serial treatment, and then would there be a cluster study with respect to them? Would only Hecate be in that category because nobody else objected?
So my understanding, first of all, is that would be up to PJM to craft that in the first instance to solve
I'm just thinking, what are you envisioning? And
Sure.
Is it permissible?
So I guess there's 2 questions embedded there. One, is Hecate a class of 1? I'm not sure about that. I mean, that's the only one that I'm aware of, which I think goes to the argument that you know, this is somehow going to bring in a huge new class of projects that's going to slow down the queue. I mean, I think to the extent there's only one that we know about that's come forward, I think that does undermine that point. But I think my understanding is that there is a way that because Hecate is willing to pay all of the network upgrade costs assigned to it, that there can be a solution where as part of the study, in other words, there's going to be a study that determines the allocation of network upgrade costs, right? That's what's being done in the transition cycle. And Hecate is saying, we're willing to pay those. So
They've been assigned to it through what process?
well, right. So it's based on the assignment. My understanding is the initial assignment is being done as part of determining which projects get into the queue, right, or get into the new process. And so that's going to be an initial assignment of what, and that's how the commission says they're going to, or PJM says they're going to determine whether something goes into the queue or into the transition cycle, is whether you're assigned more than $5 million of network upgrade costs. And we're saying, you know, we heard from PJM, well, there are these projects with small network upgrade costs that, you know, so let's say $1 million. And they say, oh, we like that. We want to stay in the expedited queue. We don't want to go try our luck over here. And our point is, yes, we've been assigned more than $5 million, but we also want to stay in the queue and we're willing to pay that. And so.
But I'm just saying that when she described those who were in the serial processing, they did in effect, a cluster study for all of them and did allocation, and you weren't part of that.
No, I don't think that's what she said. I think and I'm sorry if I'm misstating. So the legacy process, which includes the expedited process, is a serial process. So in other words, based on the queue position one is studied. Then that's determined whether that can go to an interconnection agreement. Queue position 2 is studied. Queue position 3 is studied. The clusters only come in the transition phase. And so and I think that's set out in the background sections of the brief. And our point is we want to go through that queue process. And whatever we're assigned, if it's $5 million, if it's $10 million, we're willing to pay that because we think, and we know the queue process is going to be faster because of the limited number and that it will get done before the transition cycle can complete. So we'll ask that the court vacate and remand.
I can't let you go without asking you. Do you know how the name Hecate was? I mean, I looked it up. Maybe it's the goddess of darkness. I think it's interesting that an energy company, it's actually kind of whimsical, has
Yes.
named it after.
So the goddess of the crossroads is how we prefer to characterize that. I'm not sure of all of the details of its origin, but that is where we are as a renewable company. We're looking to help the country steer on the crossroads towards greener energy and connect our process as quickly as we can to achieve that goal.
Thank you.
Thank you.
Case number 23-7160. Aenergy SA appellant versus Republic of Angola et al. Mr. Levy for the appellant, Mr. Aaronstein for the appellants.
Mr. Levy, wait till the courtroom clears. All right, good morning.
I believe I can go higher. May it please the court, Vincent Levy for the plaintiff, Aenergy SA. This case was brought in the District of Columbia District Court and seeks repayment of a debt. The plaintiff had energy contracts with the Republic of Angola and in state instrumentalities. Contracts were terminated, and at that time, the plaintiff had performed substantially more work than it was ever paid for. By this action, the plaintiff seeks repayment of those amounts. The district court found that it had jurisdiction over the case under the direct effects clause of the commercial activity exception to the FSIA. It also found that jurisdiction in Angola would be lacking because of a jurisdictional time bar that had now elapsed in Angola. The court nonetheless dismissed the case on the basis of foreign nonconvenience in favor of Angolan court, principally relying on a decision by the New York federal courts concerning a broader case in which the plaintiff had sought damages and other remedies for the termination of the contracts. We think in view of the finding that there was jurisdiction here and no jurisdiction in Angola, that the court's reliance on the New York rulings and its fresh analysis of the foreign nonconvenience factors was legally erroneous. And the court also erred in its FNC analysis in failing to hold the defendants to their burden of proof on each of the factors.
You say there was jurisdiction here and no jurisdiction in Angola, meaning I missed that latter.
Right. So below, in our complaint, we allege that our claim was jurisdictionally time barred because there's a 180 business day period to bring a claim for damages in Angola. That is
The district court didn't hold that it was time barred.
the district court credited our assertion that it was time barred. That's at page.
I thought assumed without deciding.
Well, so the Second Circuit assumed it. The district court here used the word credited, whether that means assumed or found. Either way, that's at page A127. We had made the allegation in the complaint that it was time barred. That's at paragraph 59 of our complaint. We substantiated that with legal authority and a declaration. The Angolan defendants did not dispute the point in their opening papers. They submitted a declaration on reply that we moved to strike as untimely, and which the district court declined to consider. And in its decision, the court said at A127 that it was crediting the assertion that the claim was subject to a non-waivable time bar in Angola, a mandatory one.
Why didn't Aenergy include the other claims that it brought in SDNY in the case here?
We thought that would be precluded under the doctrine of issue preclusion. We thought consistent with cases, upon refiling a case that was previously dismissed for FNC, the doctrine of issue preclusion, not claim preclusion, applies. And we thought that if we filed obviously the same claim, that would be the issue of forum non would have been decided, and the motion, the prior disposition would have been issue preclusive. But cases such as, I think all the cases we cite, such as the JSC Renfro case, the conflict kinetics case out of the Fourth Circuit, Wright and Miller, all say that if there are material distinctions between between the forum non-convenience issue in case 2 and in case 1, then the prior ruling is not issue preclusive. I think that standard is common ground. And by narrowing our case, which is what the plaintiff did in JC Renfro, we felt that we addressed the concerns of the New York courts. And we also felt constrained to file it here because, as the district court found, there is jurisdiction, and we could not bring a case for any remedy for the unpaid work claims in Angolan court.
So the claims in the Southern District of New York, there were 8 claims, and those were all arising out of the same transaction or occurrence, in the sense of there was some activity by your client. It was not remunerated for that activity.
I think that's right.
And so now when Aenergy brings only, as a formal matter, the contract claim, isn't the preclusion analysis the same? Because the question for preclusion purposes is I mean, the question for forum nonconvenience is, can the subject matter of the case that is filed here, whether in New York or in DC, be brought in Angola? And the transaction or occurrence at issue in New York and the transaction or occurrence at issue here are the same, even though only one legal theory is advanced here. And so the question then becomes, can that wrong that your client allegedly suffered find a process that will address its subject matter in Angola?
I think that this court in several decisions, including the Marian, made clear that in the situation where if a plaintiff would prevail on its claims here and obtain a relief, any relief, if that in that situation, but if in the other forum were it to prevail and establish the same facts, it would obtain no relief, then there's no basis for subject matter for a forum nonconvenience dismissal. The court, and this is at page, it's 315 F 3rd 390. Court said, this is a quote, "We fail to see how an alternative forum in which the plaintiff can recover nothing for a valid claim may also be deemed adequate. It would be peculiar indeed to dismiss Nemariam's, the plaintiff's claim, in the United States District Court, a forum in which, assuming the court has jurisdiction, she is certain to be awarded full relief if she wins on the merits of her claim, in favor of a forum in which she has no certainty of getting any relief for a meritorious claim." The subject matter of this case, the one we filed in the District of Columbia District Court, is about whether Aenergy was fully paid for the work it performed. That was a very small subset of the matters at issue in New York. The SDNY and the Second Circuit made clear in their decision that the case was about whether the termination was proper and whether it had been wrongfully procured through fraud by General Electric, through torts. Those were the issues that the Second Circuit and the New York and the federal court and the SDNY focused on.
How does it factor in about claims you could have brought in any one of the jurisdictions? Because some of the discussion essentially criticizes strategy and forum shopping, et cetera, in that you all are not pursuing the same actions or claims that could have been brought in the first instance in Angola. We are now, just coming to this hearing left with this one-page order, or actually an excerpt from the order that is 222 pages and in Portuguese. And so we don't have a way of knowing what actually happened without this translation. And that particular translation and order was also not before the district court. So two questions there. One is about what you could have brought, in terms of you're bringing different things in different forms, but what you could have brought in Angola. And then secondly, how do you feel like we are able to proceed here now that we do have something from the Angola court?
Right. So a couple of responses. One, there are decisions from this court and the Supreme Court that make clear that forum nonconvenience is inapposite if there's no other forum. And it follows also that the reason why the other forum is unavailable is not relevant. And Norex makes that clear.
Okay, and that could be two things. One is not available because the remedy is not available. Or it could be not available in this instance that they've already ruled. And so the case is over, so you can't go back and reopen the file, if you will.
That's right.
So help me along those lines.
And I think that was the situation in Norex where, if I remember correctly, there was a prior decision, I believe in Russia, the Second Circuit case. And the court said, if the prior disposition has a bearing on the case, on the new case, it would be potentially as a matter of issue preclusion or some other claim preclusion defense on the merits, but not as a threshold abstention type dismissal. So that's one point. I will going to, I think, Judge Childs, you mentioned, of course, this new development that, apologies for not providing the full translation. I obtained a copy of it last week. Needless to say, 200 pages is long to translate in 1 week. The point, though, is now that the case is over, that case in Angola, the basis for the district court's disposition can no longer stand because the entire adequacy ruling rested on the fact that a case could be brought in Angola, namely one that was proceeding. And so, for example, at A125, the court notes that the Second Circuit hinged its ruling on the reinstatement. That's at A125, and the court did so again at A127. And with that case now over, our view is because of the unavailability for jurisdictional reasons of any claim in Angola, reversal is in order because there is no forum in Angola where this claim could proceed, or any claim for relief for unpaid work. But at a minimum, there ought to be a vacatur and remand because of the development. And if the court isn't prepared to reverse, and it should because the issue of adequacy will just come right back up, at a minimum, it should vacate for consideration of the effect of this new development.
So the claim in New York was a claim for unpaid work.
There was a breach of contract claim which alleged a breach of contract. There were multiple paragraphs in the cause of action.
The way the court understood it, and you pleaded it in New York as a claim for unpaid work, no?
No, the primary remedy that we were seeking was for lost profits on account of future work that wasn't performed. We had, I believe, 3 or 4 lines in the cause of action for breach of contract that also said we also perform work that we weren't paid for. But the primary remedy that we sought in terms of damages was for lost profits, for the taking of property by Angola of namely turbines that were worth $100 million. So I think we estimated the damages in the prior case at $500 million or so. I believe the unpaid work is in excess of $100 million. So most of the damages were for lost profits as far as I can remember. And that's certainly what the court analyzed. And the Second Circuit, as the district court here said, the adequacy ruling hinged on the fact that a reinstatement remedy was being sought. That is a remedy for termination of a contract, not for work that was done and not paid for. The termination order itself said that it was without prejudice to the settlement of account, meaning that whether the termination was valid or not, there would be a settlement of account. In the first instance, our client, my client, sought to exercise its remedies under Angolan administrative law, similar to the FERC case the court just heard, to have that order reversed. That's a process, a streamlined process to have an administrative law claim heard. Typically, when this court hears administrative law claims, it doesn't get damages actions at the same time for lost profits. That's the same, in my understanding, in Angolan court. And so it first sought reinstatement. And when that failed, my client filed a case in the United States, in the SDNY, against GE, against Angola, for lost profits, seeking damages for the termination of the contracts, as well as the unpaid work. That was dismissed. And just as if a case is dismissed on a threshold issue, like, for example, for lack of diversity, and because the parties are not diverse, you drop a party and make it diverse, we refiled the case and included only the claim that was not addressed in the prior expressly in the prior disposition.
Was the basis of Energy's claim for unjust enrichment in the Southern District of New York in part the fact that Angola benefited from and didn't pay for prior work?
Off the top of my head, I don't remember. What I will say is, again, what was briefed, what was argued, what was decided was all about termination. I think the Angolan, the defendants, the appellees here acknowledge that the issue of the unpaid work was not separately addressed in either the briefing or the decision of the Second Circuit.
I'm just looking at the Southern District of New York complaint, which alleges at paragraph 242, through the conduct set forth herein, the Angola defendants gained goods and services from plaintiffs in power generation output and services without providing compensation to plaintiff for said output and services. So it seems like this is about it encompasses this question that is the focus of the case here.
Counsel, excuse me, please stop shaking your head. That's improper.
I apologize.
Go ahead.
I believe similar to the contract claim, it would be probably encompassed in the unjust enrichment claim as a mode of relief. The focus of it, though, again, was the termination and a taking of these turbines that was discussed in the prior case, where we alleged that there was a fabrication of documents by a former executive of General Electric who has been since indicted and is standing trial in the SDNY in November, that there was a fabrication of documents and that this was used to take turbines. That was the focus. I think similar to the breach of contract claim, a subset of that claim potentially encompassed the unpaid works that we're seeking here. Again, in terms of what was actually decided and what was briefed in terms of the foreign nonconvenience analysis in New York, in the Second Circuit, the focus was on the termination and the taking of property and the justifications that were made for it. This is an entirely different case, this case, that seeks a payment for work performed. We know the amount of money that my client received. That's in documents, $644 million. And the question is whether it received more or less than that amount. We claim that Angola received more than $644 million. And that claim could not have been raised in the Angolan Supreme Court, was not raised in the Angolan Supreme Court. And of course, the Angolan Supreme Court has now ruled. So there's no pending claim in Angola. And the court below, again, credited that the claim was time barred in Angola and that no relief could be sought. And the district court below acknowledged that the ruling of the Second Circuit hinged on that. The court said at page A125, the Second Circuit relied on Aenergy's pursuit of equitable remedies in finding that Angolan courts could address the essential subject matter of the dispute. Equitable remedies reinstating the contracts, and that's what the court there, the district court is referring to, citing the Second Circuit, do not address at all whether the subject matter of the dispute here, which was there unpaid work that was not compensated, and a positive remedy, positive solution, a positive resolution of the factual disputes would not provide any remedy, just as in the Marion.
So if you were to have to go to Angolan court, like putting aside this case and under the Second Circuit's forum nonconvenience holding, is it your position that Energy could get monetary compensation if it were to win an unjust enrichment claim? Could it get monetary compensation for the unpaid work?
No, I think at this point, the 180-day time bar lapsed. It lapsed, it's 180 business days, so it lapsed.
That's for the contract claim, but I'm asking about an unjust enrichment claim.
Right. The only, as far as I know, and this issue was not addressed below, the way it was briefed in the Second Circuit, we argued that the only procedural vehicle to obtain any remedy in a contract dispute is under this provision of the law, this procedural vehicle that provides a 180-day period. And so our view is there is no viable path for any remedy under any theory for the unpaid work in Angola. And I think the district court below proceeded on that basis.
That's not how I read the district court proceeding. I thought it was talking about that it was assuming that the contract claim per se was subject to that. I thought that was what you argued.
Well, I think at page A125 and again A127, the court relies on the administrative appeals that were filed challenging the termination. and A125 is the issue preclusion point, and A127 is the fresh look. In both of those points, the court relies on the administrative appeals that challenge the termination. And that's the basis that the court invokes. It says, the court says, Aenergy submits this claim as barred by a non-waivable limitations period. That's at A127. The court credits this allegation. Even so, it does not follow that Angola is an inadequate forum. Then there's law about providing the plaintiff some remedy. It says the court joins the well-reasoned decisions in New York. Angolan courts provide Aenergy with a remedy for its contract disputes. Aenergy filed administrative appeals challenging Angola's termination. And then it goes on to say that we sought reinstatement, which is all true, but it doesn't get to this point, which is that a remedy of reinstatement for termination, which by the way has now been denied, so it's not available now to the extent it ever was, does not address the dispute we have here, which is for unpaid work, and does not even concern the same subject matter of the dispute. It's just entirely different matter whether the administrative agencies, the president of Angola, abided by the law in its ruling. And I think we set forth, we have our petition, which is what the Angolan court relied on. The court has a translation of that. That's an entirely different matter as to whether in a civil suit, the plaintiff can prove that beyond the $644 million that it received, there's work that's worth more than that. Those are entirely different matters. And Angola has not argued otherwise. Angola has said that the petition in Angolan Supreme Court does include a request for compensation. That's, as we say in our brief, that's contrary to the position that its lawyers said below under oath. Angola said that the limitation period does not apply. Of course, that would be affirming on a different ground because the court below credited that it did apply, that it was non-waivable. And Angola doesn't substantiate that argument other than pointing to a reply affirmation that the court below disregarded. And so there's really no support for the reasoning of the district court. And Angola also comes up with this new argument for the first time on appeal that we self-sabotaged our own case because Judge Cronin in New York proposed to conditionally dismiss the case if on a waiver by Angola of limitation period, given that the court, well, that argument was not made below, so it's improperly raised, but the court would also, this court, if it were to affirm on that ground, would have to reverse or would have to not adopt the reasoning of the court below because the court below said that the limitation period was non-waivable. So a waiver by Angola of a limitation that is non-waivable, it wouldn't have solved anything and there's no so-called self-sabotage.
Mr. Levy, can you just fill us in a little bit on the role of the ICSID arbitration? You know, Ricardo Machado, the owner of your client's owner, has filed a claim against Angola in ICSID under the Portuguese-Angolan treaty. What's the status of that? What's the conduct that's at issue there?
My understanding is that that case concerns the taking of turbines, so there isn't overlap as far as I'm aware. I also understand, and in terms of the status, I believe that the two parties have selected arbitrators, and the two arbitrators are in the process of selecting a chair. And I understand that Angola, in that case, is disputing that the treaty applies and that there's jurisdiction under ICSID. At least that's what Angola has said in the letters I've seen in which Mr. Machado, who's the shareholder, makes a claim for compensation under the ICSID treaty.
Although they have nominated an arbitrator.
They have, and they have nominated an arbitrator, and I think the arbitrator would decide the jurisdiction question.
I was so surprised when I first started reading the papers in this case to see that there was an arbitration clause, but that nobody had sought arbitration. Can you just put that into context for us?
Right. So we did not seek arbitration. First of all, there are 13 different arbitration clauses in 13 different contracts going in a number of different directions. the defendants below and in New York asked for arbitration in the alternative. We oppose that on the basis that of numerous reasons, and the district court below did not reach the question. Some of the arbitration clauses point to Portugal, others point to Angola, but even the ones that point to Angola also provides an alternative that the arbitration could provide elsewhere under certain rules. I believe that we proposed to resolve this forum fight with my friends in Angola by proposing an arbitration in London, which is a neutral forum where the facility, where Angola had agreed to arbitrate certain disputes under the credit facility, and that offer was rejected. But
This is going ahead where?
I actually don't know where it's going ahead, the exit arbitration. I apologize. I'm not a counsel of record in that proceeding. I do know that Mr. Machado and other former employees of Aenergy do not wish to travel to Angola for fear of their personal safety, and that would be for court or arbitration proceedings. There were submissions to that effect below which were credited.
As to the recent Angolan Supreme Court decision, you're not arguing that the fact that you lost that dispute has any bearing at all on the analysis in this case?
Well, I think that the fact that has now been disposed is an alternative basis for this court to vacate. And
Why?
Because again, the analysis of the district court on adequacy, and that's page A127 and A125, hinged on the availability of and the proceedings that were going on in Angola at the time of that decision. Now that those have concluded, those do not provide a basis for a forum nonconvenience dismissal. I think Norex makes the point, as I mentioned in response to a question by Judge Childs, that potentially a disposition by a foreign court may be issue preclusive and could give rise to an issue preclusion defense on the merits, but it would not provide a basis to abstain in favor of another forum. And similarly, it would not provide a basis for forum nonconvenience. And given that the reasoning of the court here relied on that decision, relied on the pendency of the Angolan proceeding as a basis to find Angolan court adequate, now that those proceedings are over, the reasoning itself, which is what the court would review.
I'm not seeing, I mean, if I may be misremembering, because there are a lot of different decisions in this case, but I thought what the court relied on was that you chose to go to the Angolan court for at least part of your disputes with Angola. But your position is that that's a separate dispute. And so I'm just not sure that a merits loss, what light it shows. You chose to go there, you didn't prevail. What light does that show on either the preclusion issue or the fresh forum nonconvenience analysis that we're being asked to make?
Well, I think our first argument is because putting aside is that in a way this was all irrelevant because the proceeding didn't concern the termination proceedings below, so the court should reverse. If that's arguments rejected, of course, or if the other arguments we make are rejected, our view based on this recent development is that the decision below should be vacated to consider the effect of this decision because there, of course, a number of issues were tendered for disposition below, but the adequacy ruling in part, and that's again A125, which is the adequacy ruling on the issue preclusion, under issue preclusion, that hinged on the pendency of the reinstatement case. So in the middle of A125, this is in the context of the issue preclusion discussion, it says the Second Circuit did not consider, it said it was sufficient for the Second Circuit, right, that Aenergy was before the Angolan Supreme Court seeking reinstatement of the utility contracts. That's no longer true. And so that was a key factor for the district court to hold on issue preclusion that Angolan court was adequate. And then on a fresh look, which starts at A126, the court comes back to it on A127, and that's the passage I pointed the court to earlier, which references the pending administrative appeals challenging the termination. And those are ongoing. And so given that this court reviews a forum nonconvenience for abuse of discretion, if the factual predicate for the decision no longer obtains, I think the proper remedy would be a vacatur and a remand. But again, given that there's a legal error here in terms of inadequacy of the Angolan forum, given the non-waivable time limitation, we think the court should just reverse as a matter of law, just as in the Marion, which is what happened there, where there was no remedy abroad for the claim brought here. There can be no dismissal on forum nonconvenience. The Marion says that. The Supreme Court in Gilbert, which sets forth the original standard for forum nonconvenience, makes clear that forum nonconvenience is about providing a basis for deciding between two forums. And when there's only one forum, the doctrine has no application. It's a venue provision. It's not a merits-based analysis.
All right, we'll give you a couple minutes in reply. Let's hear from Mr. Ehrenstein.
Thank you.
Good morning.
Good morning. May it please the court. Mike Ehrenstein on behalf of the Angolan defendants. The sole issue really presented by this family of cases is whether or not the district court in this district or in New York or anywhere in the United States for that matter is the appropriate forum in which to adjudicate this uniquely Angolan dispute. We have an Angolan plaintiff, we have Angolan defendants litigating over Angolan contracts, negotiated, executed, performed, terminated, all in Angola, under Angolan law, and all using the Angolan national language of Portuguese. The answer to the question presented was no in New York in the district court. It was no in the Second Circuit. And we submit it should remain no here today. Now, in the district court, in this case, the plaintiff filed suit, Aenergy filed suit, saying, I'm owed money because I have not been paid for work that I've performed and services that I've delivered. And the plaintiff claims, the appellant claims, that that is much different than what had previously been argued in the Southern District of New York and in the Second Circuit. We respectfully submit that the appellant is wrong. The case in New York specifically included, although it included other claims and other parties, it absolutely included specific allegations that the appellant had performed work for which it had not been paid and that it had lost millions and millions of dollars as a result. Judge Cronin considered that argument, and the Second Circuit considered that argument. And by the way, they considered that argument in the context that is being raised again today and which was raised again before Judge McFadden, saying, but we don't have a remedy. We don't have a remedy because we're time barred in Angola. Now, we don't agree with that, and the record shows our experts contend that it's really a 20-year statute of limitations and not a 180-day statute of limitations. But even if you credit the argument that there is a statute of limitations which bars prosecution of this claim for damages in Angola, that is not the same thing as saying there's absolutely no remedy available, and therefore, at least for forum non-purposes and for purposes of collateral estoppel. The court specifically noted that there was a remedy available and that it doesn't have to be the same remedy. You don't have to have the identical type of claim available, the identical type of damages available. There was a remedy available and it was being pursued at that time.
Mr. Ernestine, is there any precedent that an alternative forum is adequate when the plaintiff brings a claim for money, for damages, and the alternative forum offers only non-monetary equitable relief?
There is, I don't know, I don't want to misspeak, Your Honor, and say that I know that there is a case that says exactly that if I'm not positive. But what I can tell you for sure is that the Second Circuit considered it and specifically held that the availability of a remedy in Angola was sufficient. And that is because the Angolan case was dealing with exactly the same essential factors that were in dispute. So, which gets us back to Judge Child's question about what, if anything, is really the impact of the decision, the recent decision by the Angolan Supreme Court. That is not of record. It is not completely translated, and we have one page of a 223-page ruling. What I have been informed is that that ruling expressly says that although the terminations were proper, the terminations of all of these contracts and rescissions were proper and affirmed, there is a pathway for Aenergy to pursue a claim for damages if it files a separate lawsuit in Angola. It certainly doesn't say pursue those claims here in the United States. What we would request, and I know it's perhaps procedurally unusual, we would like an opportunity to see a translated version of this Supreme Court ruling, and we would like a few days to highlight for the court the paragraphs which specifically say, yes, you have this claim to go and proceed in Angola for your damages.
And then I'd be curious as to whether or not the claims with respect to damages were ever brought up, like contractual damages or equitable damages in Angola, because just listening to what you just cited to us about being informed that although the terminations were proper, there is a pathway for Energy to pursue the damages. It makes me believe that there was some discussion on the record, at least.
There was.
Okay.
If I'm sorry to interrupt.
No, that's what I'm getting at.
Yes, there was, Your Honor. In fact, in the complaint in the Supreme Court, which is part of the record.
We're talking about the Angola Supreme
Yes,
Court.
yes, ma'am.
Okay, just want to make sure we're in the right court.
Yes. In the complaint in the Angolan Supreme Court, which is also a very large document, there are paragraphs within that complaint in which Aenergy specifically alleges, by the way, these terminations have harmed me. By the way, these terminations have resulted in me, in Aenergy, not getting paid for the services it has provided. And Aenergy specifically alleged, we reserve the right to be able to pursue that at a later point in time. That's in the complaint. My understanding of the recent ruling is that the Supreme Court of Angola acknowledged that and said, although these terminations are correct, if there has to be an adjustment of the accounts between the parties, because by the way, I think Angola claims that it's due money back from Aenergy, that has to take place in court in Angola in a separate lawsuit. So to get back to the issue presented, because it is the same case, the same transaction or occurrence as Judge Pillard had been asking about, the same issues, the issue of forum nonconvenience that was decided by the Southern District of New York and affirmed by the Second Circuit does collaterally estop the renewed prosecution of that claim here. Now,
Does the public interest analysis, is it affected? You say that the balancing of public and private interests is the same in this case as in New York, even though the contract claim before us doesn't allege wrongful termination of the contract. It's really looking at what happened before termination. And you say, well, the defendants will rest on their justification for terminating the contracts. And that's the same evidence. But I don't see how a valid termination would relieve Angola of any obligation it may have to pay Aenergy for work that it already had.
I think we agree. Angola is not, Angola's position, the Angolan defendant's position is and has always been since the date of the termination. If there's an adjustment of the accounts between the parties that needs to take place, it must take place. That was in the president's decree, and it was affirmed now by the Supreme Court of Angola saying that that has to take place. Whether Angola owes money back to Aenergy for its services and goods that were not paid for, or whether Aenergy owes money back to Angola for overcharging for services and goods that Angola never received, that's an issue that has to be adjusted. But for purposes of the Supreme Court decision in Angola, it said the termination was proper.
But you don't think that that difference, that the narrowness, the relative narrowness of the case before us changes the public and private interest balancing
If any,
that
I'm sorry.
was done in the New York case, such that we can't say it's the same issue here, were we to be analyzing this under preclusion?
If you look at it under preclusion, I think it has, there's no objective facts that are materially different in terms of the private and public interest. If you take a fresh look at it, finding that collateral estoppel does not bar the claim, and you look just at forum on convenience separately, the private and public interests are largely the same as in the New York case, but even more so, what tilt now more in favor of the Angolan defendant's request for forum non-convenience dismissal. And the reason we say that is because in the New York case, there were other parties that did have presence here in the United States. There were certain witnesses which may have been present here in the United States, and there were documents and related claims that were commingled that were here in the United States. Here, there is no interest that this court should have or can have in the solely Angolan dispute, which is going on here.
Haven't you just argued yourself out of preclusion? It doesn't matter which way it cuts, but if the issue here is different, then why would we rely on preclusion? You seem to there be leaning into a fresh forum non-convenience analysis, but are you thereby abandoning your preclusion analysis? And it sounded like you were.
No, I hope that is not the message that I'm delivering. What I'm saying, Your Honor, is that preclusion applies and bars the claim. However, based on
Didn't you just say the public and private balancing is different?
I said, if you take a fresh look at it, if you say that you're going to ignore preclusion and not apply it, then under a fresh analysis, it would be largely the same, but more so in favor of the Angolan defendants.
Under a fresh analysis, it's your burden to provide the district court with sufficient evidence to determine that an adequate alternative forum exists.
Yes.
what evidence did you provide to the district court in this case?
Well, there was a couple of things. First, that we had incorporated and relied upon the decisions of the New York court.
But you didn't provide the evidence you provided in New York to the court here for its own evaluation.
We ultimately did. We did provide an affidavit or a declaration of Enrique Abacasis in support of our motion to dismiss, which spoke about where the witnesses are and where the documents are and the language and the convenience.
That's not about the adequacy of the Angolan form.
That's correct. Yes, Your Honor. With respect to adequacy, I'm trying to remember, argued
I'm not aware of you ever having provided any evidence on the adequacy of the Angolan forum, or even asking the district court to take judicial notice of the factual record. In the Southern District of New York case, you asked for judicial notice of legal proceedings in Angola,
yes.
but I'm not aware of any place, and if you point me to a place where you did, but I'm not aware of any place where you asked the district court in this jurisdiction to take judicial notice of the factual showing in the Southern District of New York record. So I'm not sure how we could do a fresh
Your Honor,
form nonconvenience analysis here, given your burden.
you are correct that there is no specific language within our briefing saying, please take judicial notice of the New York case. We did at the inception of the case identify the New York case. I'm sorry, at the inception of the district court case here, identify the New York case as a related case and highlighted the fact that even the appellant had indicated that it was substantially related, and when it filed its motion to state substantially related parties and claims and facts. So that is the extent of the request for judicial notice. There wasn't any formal judicial notice request. However, when we briefed the issue in the motion to dismiss, we argued, based on the arbitration clauses that you focused on earlier, that the burden on forum nonconvenience and adequacy was, and on everything, had been shifted as a result of the Atlantic Marine analysis. When you have a forum selection clause, which in arbitration, we contend that arbitration clauses here are a species of forum selection clause.
But that's only when you've selected the particular forum that you're then proceeding in. That doesn't have any application to a third forum. Like that would render adequate the arbitration forum.
Which we did ask the court, in the motion to dismiss originally, that was in the motions to dismiss here and in the motions to dismiss in the New York case, we did ask for the court to send the cases to arbitration based on the arbitration clause.
I'm sorry, I interrupted you. You were making this point based on, is it Atlantic Marine?
Yes, because of the burden shifting that occurs when there is a forum selection clause that we did not produce evidence and declarations and refer to the record in the New York case at that time because we felt that our burden was being sustained by law when there was a...
Because there was an arbitration clause.
Correct.
And an arbitration clause is a form of forum selection clause.
Yes, ma'am.
But there was no forum selection clause selecting Angola.
There was a forum selection clause that was almost identical in all of these contracts. The excerpts of...
It didn't select Angola.
Well, it did. It selected Angolan law, and it gave two different Angolan arbitral procedures that could be followed.
But you
It
weren't
didn't say venue.
I'm maybe missing something obvious, but you weren't asserting that this case should go to arbitration.
We did.
So you were, I mean, I didn't read your brief as saying, oh, put aside whether the Angolan court system would be adequate, because everybody has to agree based on the arbitration clause that an arbitral forum would be adequate. That's
Right.
what I hear you to be saying now, but I didn't understand you to be making that argument in your.
I was not. So let me try to clarify. The argument to refer to dismiss and refer the cases to arbitration was made in our motion to dismiss. The court chose to rule only on the forum nonconvenience and collateral estoppel issue. When it made that choice, we argued that the arbitration clause changed the burden for purposes of forum nonconvenience. And it changed it from us having to bear the burden of demonstrating adequate alternative forum to the appellant having to bear that burden. And that in almost every case where there is a valid forum selection clause, that burden is borne, is satisfied. Then afterwards, because you were asking about whether we submitted anything else, after the plaintiff, after appellant filed its response to our motion to dismiss and said, yes, but you haven't filed anything. At that point in our reply, we made reference to all of the declarations that had been filed in New York. Those declarations were submitted, and Aenergy moved to strike, saying that this was new argument being raised on reply. And Judge McFadden never reached that issue. He said he's denied the motion to strike as moot. But we did put in record evidence of the adequacy of the forum as well as the convenience factors. With respect to the adequacy of the forum, I would point the court to the declarations of Professor Diamvatu, who wrote at length about the statute of limitations and its effect.
All right, if there are no more questions, where is the arbitration being conducted?
I don't know, I'm not counsel, but it's my understanding that it's going to be conducted here, but I don't know.
Thank you. Okay, Mr.
I don't want to monopolize your time. If you don't have any other questions, thank you very much for your attention.
Right. And if you'll give Mr. Levy 2 minutes.
Thank you, Your Honor. A few things. First, I do think there's effectively a concession that issue preclusion does not apply. And on a fresh look, the court must look to the evidence that was submitted. There was no evidence on adequacy. The evidence of the other factors was lacking. And a mere citation to the findings of the prior court on the assumption that issue preclusion does not apply surely cannot be enough on a fresh look. Now, my friend says below and here he relied on the arbitration clauses, and he cited in his briefing the Dowman case, for example, from this court. I think it was an unpublished decision. The court there looked at an arbitration clause through the lens of the forum nonconvenience analysis, but the motion was to go to arbitration. And here, the motion is to go to Angolan court, and the court below did not reach the arbitration arguments by the party. That's at A135, footnote 6. With respect to the reply evidence that was submitted, we did move to strike it untimely. As my friend says, the court did not consider the motion to strike because the court declined to consider the evidence. And therefore, so far as the motion record is concerned on a fresh look, there is no evidence. And under Deb, the Seventh Circuit case that we cite, that's not good enough. This court's decision in Simon, there was a similar deficiency in Simon versus Hungary that Your Honor authored. There was a similar deficiency on some of the factors with respect to some of the evidence. With respect to the Angolan Supreme Court decision, we think the court should address the arguments we've raised as they are stated, and that the timeliness issue was properly tendered, and that a reversal is in order for that reason, and that to the extent the Angolan Supreme Court decision has further bearings, that could be for remand, if anything. Thank you.
Thank you. We'll take a short break.
Ben, this honorable court now Stand, please. This honorable court is again in session. Be seated, please. Case number 23-5038. Carter Page appellants versus James B. Comey et al. Mr. Scher for the appellants, Mr. Kelly for the individual appellees, Mr. Schultz for the government appellees.
Mr. Chair, good morning.
Good morning, Your Honors. You've already had a long day. My name is Gene Scher, and I'm pleased to be here representing Dr. Page, who is here in the audience with us. Whatever one may think of Dr. Page or the president-elect that he served during the events at issue here, this case is controlled by a bedrock procedural principle, one that's grounded in fairness to all litigants, and that is that on a motion to dismiss, the allegations must be accepted as true along with any reasonable inferences from them. And this court has recently emphasized and reemphasized that principle in a number of cases, including Simon versus Hungary and the Rodriguez case. And when that principle is fairly applied, it's clear that the complaint here adequately alleges that the defendants committed 4 distinct actionable offenses against Dr. Page, which I'll address in order. The first is his claim against defendants Stroke and Page and anyone who acted with them for unlawfully disclosing FISA-acquired information about him to the media in violation of 50 USC section 1809A2. Next is his claims against all the individual defendants for unlawfully using and disclosing FISA-acquired information in the renewal applications that they filed with the
Mr.
FISC.
Chair, on the media theory,
Yes.
can you identify what information you're relying on, suggesting that Stroke or Lisa Page leaked information obtained from the FBI surveillance as opposed to the mere fact of surveillance?
Yes, and I'm happy to describe that now or later, but
Just putting a pin in it. Go ahead, because you were summarizing your theories.
yes.
Renewal?
And those are actually in the FISA applications, which we now have, that have been partially declassified, but I'll get to that in a moment. Third is Dr. Page's Patriot Act claim under section 1806A against the government, which is also based on improper disclosure of FISA-acquired information, both to the press and in the renewal applications that were filed with FISC. And finally are his claims against the individual defendants for engaging in unlawful surveillance in violation of section 1809A. So with respect to the claim against Stroke and Page and anybody else who acted with them, that cause of action arises from his allegations that they unlawfully disclosed FISA-obtained information to the media, as I said, in violation of 1809A2. And if you look first at his complaint, which is where we have to start to see his allegations, counts 2 through 4 allege generally that all the defendants, among other things, unlawfully disclosed information obtained pursuant to FISA warrants. But if you look back in the complaint in paragraphs 225 and 26, those are incorporated by reference in counts 2 through 4, and they provide ample detail as to Stroke and Page's media leak strategy, which actually became famous in the press. They texted with each other, and those texts became public about how they were going to leak information from the Carter Page investigation, and it turned out that some of that was, we believe there's good reason to believe some of that was from the information that was obtained through their earlier FISA applications.
So it does say that they leaked existence of the warrants, the contents of the applications, and the results of the warrants. It seems to me that the
Yes.
statute only covers the results of the warrants.
That's correct.
And is there anything more concrete to substantiate that any of the people who reported knew anything about the results of it?
There's a little more information about that in paragraph 225, where it says Stroke and Lisa Page collaborated to disclose protected information regarding Dr. Page to the media and sought and obtained approval to do so for Mr. McCabe. And obviously, if those allegations are true, and truth has to be assumed at this stage, then they are sufficient to establish a violation of 1809A2 as to the execution of their strategy. Now, your next question may be, why do we think that's plausible, right? And what is there in the complaint that makes it more plausible than mere speculation? Well, it's important to remember that the complaint incorporates by reference, it mentions and incorporates by reference all of the applications that were filed with FISC, which were declassified not until February of 2020, okay? And we've provided those to the court in the addendum. And I would invite you, if you would like to turn to page 238 of the addendum, which contains some information that makes the more general allegations of the complaint even more plausible. 238 is from the, is from the second renewal application, which was submitted to the FISC, I believe, on April 7th, 2017. And if you look at page 232 of that application, which is page 238 of the addendum, you'll see about halfway down the page that this application says, although Page publicly and in interviews with the FBI has denied meeting with Sechin and Divyekin during his July 2016 trip to Moscow, those were apparently well-known Russian operatives, okay? So there's that discussion about his possible meetings with them. And then notice what comes immediately thereafter in this document. The rest of the information is blacked out, and it says FISA acquired information subject to sequestration, giving rise to the inference that the additional information there, which was presented to the FISC but not available to us yet, was obtained through surveillance under the prior warrants.
Right, but to the extent you're addressing Strokes and Page's leaks to the media, what is covered is
that's next.
FISA acquired information, and that information is not, okay.
Yes, that is absolutely next, Your Honor. But I do just want to, before I go there, I'd like to point out one additional aspect of this application. If you scroll down to page 241 of the addendum, there's another little paragraph about Page's international travel. And the first part of that is once again blocked out as FISA acquired information. And then it says the FBI believes that the RIS, that's the Russian intelligence services, and Page may be meeting face to face. And then it goes on, and there's other information that's blacked out. Okay, so what does that have to do with the Washington Post article, which is the key event? Well, when you combine the timing of this application, which was filed 4 days before the Washington Post article came out on April 11th, and then when you compare what we've just seen in that application that's blocked out as being FISA acquired information, but we know something about it. You can assume that it has something to do with the Russian intelligence service and those two particular gentlemen that are listed there on page 238. And then if you then go to the Post article, which is It's at Joint Appendix 97. Okay. The first page of it is on the prior page, Joint Appendix 96. No, I'm sorry, 95 is where the article begins. But if you look at page 97, at the top of the page it says the government's application for the surveillance order targeting Page included a lengthy declaration that laid out investigators' basis for believing that Page was an agent of the Russian government. Of course, the FBI later admitted that that was just false. Okay, and the FISC scored them for it. But anyway, the article talks about the lengthy declaration that was part of the basis for this application, that Page was an agent of the Russian government and knowingly engaged in clandestine intelligence activities on behalf of Moscow, officials said. Again, the FBI later admitted that was just false. And then here's the key paragraph, the next paragraph. Among other things, the application cited contacts that he had with Russian intelligence operatives in New York City in 2013, officials said. Those contacts had earlier surfaced in a federal espionage case brought by the Justice Department against the intelligence operative and 2 other Russian agents. And then here's the key sentence. In addition, the application said Page had other contacts with Russian operatives that have not been publicly disclosed, leading again to the inference that what the reporter was talking about there and the information that she had gotten from Strzok and/or Page was information about additional contacts with Russian operatives, which, when you look at the application, it's pretty clear that information is coming from prior FISA surveillance under the prior warrants. So, based on all of that, certainly the allegation is plausible.
Why is it not, why is this notation in Addendum 238 referencing the federal espionage case brought by the Justice Department previously?
Why is it referencing it?
Why is it not referencing that? Like, why do you connect the media's reference here to prior surveillance of Page as opposed to other prior espionage?
Well, because when you, it's an inference, Your Honor. It's not, we're not dealing in certainty here. All of this information is classified. That's what makes this case so difficult. But so drawing inferences, as we must, if we go back in time a little earlier, if you look at the very first application that was filed for surveillance of Carter Page, there were no redactions of this kind, okay? No redactions that said FISA acquired information subject to sequestration, okay? The second application, which was the first renewal application, had 16 instances of redactions like this, okay? Suggesting that there were 16 bits of information that had been acquired in the first round of surveillance that were then presented to the FISC in order as a basis for continuing to investigate and continue to surveil him. And then in the second renewal application, which is the one we're looking at right here, if you count them up, there are a total of 22 references to FISA acquired information, suggesting again the FBI was continuing to get more and more information as a result of its surveillance of Dr. Page, and the thing was kind of building on itself and snowballing.
And I take it in your theory, it doesn't matter whether the information that's disclosed is putatively supportive of probable cause or not, because the application just requires updating on what was found, even if it's completely innocuous.
Right.
It would still be disclosure of information obtained through a FISA tap.
Yeah, and so for purposes of this claim against Strzok and Page, the key fact is that they took this information that had been acquired as a result of their prior surveillance, and they passed some of it on to the Post reporter. who wrote about those Russian contacts that had not been previously publicly disclosed. Again, we're not absolutely certain, but that's a fair inference from the allegations of the complaint and the warrants that are incorporated by reference in the complaint.
Let's address how you get past statute of limitations issue.
Yeah.
You know, just with respect to having information through the Washington Post article, April 2017, in which Page actually makes statements.
Yeah.
So, you know, therefore having some knowledge with respect to discovery rule. Then you're responding also to the House committee, and then you've also got the November proceeding.
Right.
All occurring in 2017. And so the discovery rule essentially is indicating that, you know, what do you know when, and then do you have diligent efforts to find out more that leads you there? And of course, the district court found essentially that, yes, there was knowledge acquired at a certain point in time, but seemed to have gone to a somewhat of a heightened standard of discovery, as if there was something more, although not based in our case law, you know, requiring that heightened.
Well, I think it's important to remember that there are multiple different claims floating around here, right? One potential claim by Dr. Page would be against the FBI for the original surveillance. And certainly, you know, the Washington Post article gave him notice that he was injured from the original surveillance. But what's central to this particular legal theory against Stroke and Page is that it doesn't rely on the original surveillance. What it relies upon is their providing FISA-acquired information to the press in April of 2017, information that they had probably just barely acquired, or they had just barely listed that in their second renewal application to the FISC. In any event, and there was no way, if you look at the historical record, there was no way that Dr. Page could have known about this kind of misuse of FISA-acquired information until the Horowitz report. Because the Horowitz report, through its redactions, in the public version, it made pretty clear that there had been some fruits of FISA surveillance that had been used. So that was, you know, that was in December of 2019. And then the next key event was the declassification of the redacted versions of these warrant applications. They kind of came out seriatim during February of 2020, and so what I just showed you earlier could not have been known to Dr. Page until February of 2020. And then, of course, it was later that the FISC itself revealed that the Justice Department, the FBI, had admitted that the whole thing was fraudulent from the beginning. I mean, they admitted that the third and fourth applications did not adequately provide probable cause, but logically, you know, that took the legs out of the whole enterprise.
Explain your view of why only 3 and 4 and why that takes the legs out. Because they don't say that 1 and 2 are.
Again, if you look at the development of these warrant applications, if the third application, which was the second renewal application, that application had a lot more information in it than the prior applications. So if that third application, the second renewal application, did not provide probable cause to surveil Carter Page, then a fortiori, the earlier ones could not. At least that's a fair inference, because it wasn't as though the prior applications had more information than the later ones. Because what was going on is that the FBI was just periodically admitting additional misdoing. And it was because of their admission with respect to their misdeeds as to the third application that that they said there's no probable cause here. But again, logically, if that's true of the third application, it has to be true of the first and second ones.
Well, didn't Judge Boasberg, let's see, he assumed that the same thing applied to the first and second applications.
Yes.
As the third and fourth.
Yes,
That is, that there was no factual or insufficient factual
that's exactly.
support for probable cause.
That's exactly right. And that was in June of 2020 when he said that. He made that very point that I just tried to make. That given that they're admitting that the third and fourth didn't provide probable cause, that necessarily means that the first and second didn't. In fact, he said, I gave the FBI an opportunity to explain to me why they think the first and second might have provided probable cause, and they didn't. They didn't even make an argument. They never admitted that the first and second didn't provide probable cause.
But they did not differentiate.
But they did not even attempt to defend those once they had admitted as to the third and fourth.
Well, they didn't differentiate the 1 and 2. That's what Judge Boasberg said.
I think they did differentiate. Well, I think they specifically said, we acknowledge that the third and fourth did not provide probable cause
And we're
for
silent
surveillance.
as to.
And they were silent as to the others. Judge Boasberg said, I'm going to give you a chance to justify those, and they didn't. Okay? So given the requirements applicable at the pleading stage, the relatively relaxed requirements, this claim was not overly speculative or conclusory, as the district court concluded. It was, in fact, more than sufficient to get over the bar of a motion to dismiss, and it was therefore error to dismiss that claim.
When we look at Hobson versus Wilson,
Yes.
where there was unjustified surveillance of individuals who had read news articles reporting the FBI's unconstitutional COINTELPRO operations, and the plaintiffs also knew they were FBI targets, we held there that the statute of limitations ran, that the secrecy of the operations didn't tell them because there was some news putting the plaintiffs on notice. Why is that not also true here, where the Washington Post article quotes Dr. Page saying, this confirms all my suspicions about unjustified, politically motivated government surveillance. And in fact, he himself compares it effectively to the COINTELPRO unjustified surveillance. And in his letter to the congressional leaders, he says, my FISA warrant is filled with a potpourri of falsehoods, fabricated from the outset. So, and as the defendants say, that is his theory in the lawsuit, and he was stating it publicly back in 2017.
Well, I think this gets back to the earlier discussion with Judge Child about the different kinds of claims that are at play here. Certainly, the other side has a much better statute of limitations argument to the extent that Page is challenging the original surveillance warrant and the surveillance that was conducted pursuant to that warrant. But the Hobson case, and I think the key language, if I can find it, is that the court said the plaintiff must know facts giving notice of the particular cause of action at issue. Okay, so if we were talking here about a claim for unlawful surveillance at the outset under the first warrant, Mr. Page's statements and the Washington Post article and all those sorts of things, they would give the defendants a stronger statute of limitations defense. And again, it is a defense, right? They haven't even pleaded it yet. They haven't even answered. So we don't even know for sure that they're going to invoke that defense. Maybe they have tactical reasons not to. Probably not.
Invoke which defense?
A statute of limitations defense.
But they're allowed to raise it by motion.
If they think that it's established in the complaint itself,
Right.
which it's not. But But if we're just talking about, the facts, the claim that I'm talking about right now with respect to Stroke and Page is not a claim for challenging the original surveillance under the original warrant, or even the surveillance under the second warrant. This claim that we're talking about right now is a claim that challenges their disclosure of FISA acquired information in violation of 1809. I think it's A2 is the provision. A1 is surveillance itself. A2 is the disclosure of the fruits of the surveillance. And that's the claim that we're talking about now. And for reasons that we've discussed, there was no way that Dr. Page could have known that they were actually disclosing the fruits of the FISA acquired, of the FISA surveillance to which he was subject, as opposed to other things that were not FISA acquired surveillance, things like the Steele dossier and a host of other things that people were citing during this period when they were trying to allege a connection between the president-elect for whom he worked and Russia. So I hope that answers the question with regard to the statute of limitations on this particular claim. And obviously, you have to look claim by claim. But again, I think the key language in Hobson is the statement that says the plaintiffs must know facts giving notice of the particular cause of action at issue and not just any cause of action. And the particular cause of action is the A2 claim for unlawful disclosure of the fruits of FISA surveillance.
And your point, just to close the loop, is that it's the release of the redacted applications that closes the circle?
That is what I think would put him on notice that he had that kind of a claim. Yes. Not even, and I don't even think the Horowitz report quite gets there. The Horowitz report kind of suggested that there was some fruits of the FISA surveillance that was used, but it wasn't until those actual applications were released so that you could see how the FBI was using FISA acquired information to buttress certain allegations against him. I mean, they were trying to smear him, right?
But if you go back to, again, May 2017, that's the point at which he's in front of dealing with House Intelligence Committee, and he's mentioning felonies related to leaking and his identity.
Right.
Then you go on to November 2017, and he's testifying about information that was collected against him illegally.
Right,
So
but he
you don't
doesn't
have to
know
everything at the time of filing.
Well, again, the claim we're talking about is a claim for unlawful disclosure of the information that's been collected, okay? The stuff that he talked about in 2017, yeah, those might well have given rise to different kinds of claims. I mean, there were a whole series of violations that occurred here, and we're focused on the ones that we needed to limit our appellate issues, and we're focused on the ones that we think are absolutely 100% defensible.
So, but that theory only applies to the disclosure claim with respect to the media leaks, because
Correct.
The disclosure claims with respect to the renewal applications and briefing of other people within the Bureau, those are.
That's a separate.
If you know there's unlawful surveillance based on, made up information, those things are going on.
Well, that's the second cause of action that I wanted to talk about is that specific unlawful use claim. Again, that
I think of it as sort of a pair. The renewal application requires that you report on what you found, so that's a use, or I guess a disclosure, and then briefing within the Bureau I take also to be
right.
A claim that he made, and the personnel involved may be slightly different.
Yeah, and they involve different they involve different unlawful behavior, right? In the case of the Page and Stroke claim or legal theory, the unlawful behavior is leaking the information to the press without authorization. With respect to the claim about using FISA acquired information improperly and seeking additional warrants, the unlawful behavior is in using that FISA acquired information to create the illusion that the FBI is entitled to continue surveilling him, even though, as we know from the FBI's subsequent admissions and from Judge Bosberg's pointing out that they never ultimately tried to defend the first and second applications at all, we know that surveillance was unlawful as well because it was not supported by probable cause, and the people who wrote and supervised those applications were taking FISA-derived information, as we saw in the example, and there are a couple of other examples that I'll be happy to show you. They were taking FISA-derived information to create the illusion for the FISC that they actually had probable cause to continue surveilling Dr. Page.
Were they, I mean, Page himself pleads that they turned up 0 that was, in any way tending to be inculpatory.
Well, that's not exactly what he said. He said that they did not turn up evidence that he was an agent of a foreign power. Okay, and in the example that we just saw,
isn't that the relevant question?
Yes, it is. But in the example that we just saw, the FISA acquired information that they used to smear him was not showing that he was an agent of Russia. It was simply showing that he had contacts with certain people. And so he did say they never came up with evidence that I was an agent of Russia. And that's true, and that remains true, but they came up with a lot of evidence that they used to smear him as having, excessive contacts with people in Russia and people connected to the government in Russia. And those are two different things. So again, if you look at the allegations in the complaint, the complaint, I think, quite clearly, if you parse through the different provisions, quite clearly makes the point that he was challenging the FBI's use of that FISA acquired information. He says, and if you look again at counts 2 through 4, the complaint says that having obtained communications through the earlier FISA warrants, the defendants, quote, used and disclosed those communications to obtain the subsequent ones. In other words, to create the illusion that they had probable cause to keep surveilling him. And then paragraphs 229 and 30 describe all of that in more detail. And it's, and again, I would just invite us to look at a couple of other examples if I can get my computer to turn on. Well, I can't.
But he does testify that there was a ton of information that was used against him illegally and collected with respect to evidence in that FISA matter. And so I know you keep distinguishing, we have an initial application, we're using the information collected from the initial application going over into the other ones. I'm just not quite sure that I'm catching that distinction if he is outwardly and blatantly testifying that I know they have all this information, it's false. They're using it under false pretenses. They're identifying me specifically. They've also leaked it at these points in time in 2017. Then what else does he need to go forward with his complaint other than amend as you acquire more information?
And Your Honor, I don't want to be argumentative, but just
Sure.
if I could contest the premise a little bit.
Sure.
I don't think any of those statements, any of those earlier statements that you mentioned actually said they have unlawfully used the fruits of their FISA surveillance against me. There was a lot of information that they used improperly, beginning with the Steele dossier, which was not FISA acquired information. It was completely independent of FISA. And you know, and if you look at his statements, I think a fair reading of those is that those were the sorts of things he was talking about. I really don't think you could have, you know, again, to use the language of the Hobson case, I don't think there was any way that he could have known of the exact illegality that he later complained of in the two claims that we're making now.
I wonder if you would address the claim of engaging in electronic surveillance, the claim that the district court held applies only to the people who are sort of directly involved in
Sure.
the mechanics of the surveillance, and what you think that actually covers.
Well, I think the evident error in the district court's analysis of that issue can be illustrated by a simple example. You know, suppose that you have a police sergeant sitting next to a young corporal, okay, and the department has decided that they're going to wiretap somebody. The corporal is the guy who has the headphones on and is actually listening to the conversation, right? The sergeant is sitting next to him, supervising his activities, and by the way, asking him periodically, "What did you hear? What did you hear?" Right? And under the district court's analysis of engaging in it's only the corporal that has the headphones on that's actually engaging in surveillance, not the principal, that is the sergeant, who's directing him and overseeing him and getting periodic reports and that kind of thing. And that is just that is an unrealistically atextual reading of that term engaging in. You know, as we did.
It's not clear where exactly she would draw the line because she wasn't faced with that, you know, close of a case. But if there is sort of a category of authorization and then a category of execution, I think she's saying, you know, engaging in it, just language supports reading it, and in the context of the statute where there's other references to preparation, just supports reading to apply to some more carrying out kind of conduct. Right.
Well, with respect to the district court, that's a red herring here, because we're not challenging under this particular provision, 1809A1, which deals with engaging in surveillance. We're not using that to challenge the initial applications. Okay. That's a different claim. That's an A2 claim that we've been discussing just a minute ago. An unlawful use of FISA acquired information. Okay.
That doesn't apply to the initial applications. That only applies to the renewal application.
Correct.
Okay.
Correct.
So what are you using the engaging in to get at?
Well, again, the A1 claim is a separate claim.
Yes.
And we believe, and the complaint alleges, and we've contended all along, that especially in the acting pursuant to the renewal applications, the FBI and the various individual defendants who were involved in that, they were engaged in unlawful surveillance, not just the use of surveillance, but they were engaged in unlawful surveillance because they knew that there was never probable cause to surveil Carter Page at all. And the additional surveillance was merely an effort to create a smokescreen to make it appear that they had probable cause to surveil him. That's the reason the engaging in surveillance was unlawful. It wasn't, for that particular claim, it wasn't the preparation of the warrant applications. That's an A2 violation because they used the fruits of the earlier surveillance. What we're talking about now is the A1 violation for actually engaging in surveillance. And again, we believe, and the complaint alleges, that that was unlawful because it was a charade. The whole thing was a charade. They knew from the outset that there was never a basis to surveil Carter Page. And everything they did from then on until they finally came clean, years later, everything they did from then on was just to try to make it look like there was some validity to what they were doing. They were trying to cover their tracks. And that's why the surveillance was unlawful.
So what's your theory that the engaging in claim is not time barred? Because that more is what Dr. Page had stated that he thought was going on when he was talking to the Post, when he was interacting with Congress.
Certainly the statute of limitations argument as to the initial surveillance is, the other side has a stronger argument that that's time barred. As you go forward in time, the statute of limitations argument becomes less strong because there were additional things that happened to put Dr. Page on notice that yeah, he was really right, that this whole thing was a charade from the outset.
And you're specifically referring to the Horowitz report and the release of the redacted application.
Correct, and the FISC statements in June of 2020 and all those sorts of things. But again, it's important not to confuse those two claims when it comes to the statute of limitations, because the statute of limitations argument as to the engaging in surveillance is very different from the statute of limitations argument as to misuse of the FISA acquired information.
All right, you need to wind it up.
Okay. Well, let me just conclude by saying that the three provisions on which Dr. Page has based his claims are essential to the ability of ordinary Americans of all political persuasions to hold their government accountable for the kind of malfeasance that's plausibly alleged in Dr. Page's complaint, and the district court's improper dismissal should be reversed. Thank you.
We'll give you a couple minutes in reply.
Thank you.
All right, Mr. Kelly.
Yeah.
Mr. Kelly.
May it please the court. My name is David Kelly.
Before you begin,
Yes, ma'am.
I just want to get a couple of things clear. First of all, are we allowed to know who actually conducts the surveillance? That is, are they contractors, are they FBI agents, or are they FBI non-agents?
I don't know the answer to that, Your Honor. I would only have to speculate on that.
All right, and then do we know, are we allowed to know what was actually surveilled?
Again, Your Honor, I'm not sure what the fruits of the surveillance actually were. I think we'd have to go outside the record here to determine what that was.
What was surveilled?
Yes.
In other words, his
In other words-
iPhone, his laptop, that's what I'm asking about.
Yes, Your Honor. Well, I think it was his phone and his laptop, but I have to confirm that.
And is this, I mean, this is just a general question. When we watch the movies, we see someone sitting in a van with the headphones on, as Mr. Scheer was referencing. Is there still some mechanical thing, or is it like you contact Verizon?
Well, there's a variety of different ways depending on the device, Your Honor. But what's important here is that there are no allegations that any of these defendants were involved in any of that process at all.
I guess part of understanding the reasonableness or not of the interpretation is whether there's any there if you read it the way our colleague on the district court did. In other words, if all we're doing is asking Verizon to give us, to keep track of and give us some information, give the Bureau some information, then the notion that the person who's conducting is going to be responsible is quite a different object of legislative attention than the notion that somebody is going into someone's house and putting a bug somewhere.
It's a fair question, and I think I defer to my friend in the government who is going to be taking the podium after me on that. But, and I think it varies with the type of technology, but yes, from my experience in government some time ago, it still is the case where there are people who are actually involved in listening in one form or another. It's not Verizon who's doing the listening. It's agents of the government, whether they be agents or contractors. There's agents of the government who are actually listening and actually conducting their surveillance here. And what we're talking about in this particular case, and by the way, I'm here while I represent the defendant appellee, James Comey, I'm also here to argue on behalf of each of the individual defendants. But in this particular case, there are no allegations that any of them did anything apart from being involved in the process of applying for the surveillance and having nothing to do with the actual surveillance. And with regard to that, it's also important to note that there are very distinct levels of participation in that process, some more than others, but in any event, none approaching anything relating to involving surveillance.
Well, let me ask you about, do you have the definitions under 1801 in front of you?
I do not, Your Honor, but I know it pretty well.
Can you get it?
Engage in, well, what it comes.
I'm asking about a clause that nobody has interpreted in the definition of electronic surveillance.
And that is?
And that clause is, if the contents are acquired by intentionally targeting that United States person. And I'm asking you if it's a fair reading to say that more than one person targeted Carter Page.
I think it's fair to say that the government collectively targeted Carter Page because of the belief that it was an agent of a foreign government, as that is defined under FISA. And I think that was, fleshed out somewhat in the Horowitz report. The fact that they had a basis to conduct that investigation. The question was whether or not they had sufficient probable cause to get the FISA warrant.
Let me ask you this. Why did defendant Comey not intentionally target Carter Page? Why did McCabe not intentionally target? In other words, one of the two of them signed or authorized the application, signed the application to get the.
So to be clear, Your Honor, the certification provided by the director of the FBI doesn't have anything to do with the underlying facts, but certifying the purpose of the application, that it complies with the purposes of FISA for investigating an agent for.
But it's directing the targeting of Carter Page, or it's approving the targeting of Carter Page.
I don't think it's fair to say in this context or in most contexts that an individual targeted another individual. This was a collection of information that was gathered by the agency, and then it was authorized for the purposes of carrying out the purpose of FISA. And I don't think that you can say that there was an individual amongst these defendants or amongst any group of individuals who targeted this plaintiff. It would be a collective.
It depends on how you're reading targeted. I mean, targeted it could be seen as a much more just almost a physiological explanation of, it's one thing if you're at a party and you overhear something, you're an agent and you have a hearing aid and you pick up things that, someone around a corner might not think you would ordinarily be able to pick up. And so you're using an electronic thing and you hear them, but you weren't intentionally targeted. You picked it up by accident. I mean, that's one way of understanding, as opposed to like a bias related.
Well,
and here it seems indisputable that they were intentionally targeting him. Putting the surveillance in place is intentionally targeting this individual.
Right. So I think what the answer to your question is found in the background of the Crossfire Hurricane investigation, which first came to the attention of the FBI through a source through the Australian consulate who had spoken to somebody involved in the Trump campaign who identified the fact that there may be connections to the Russian government. And from there, the investigation began as to who that might be. So I think that, again, I wouldn't say that it's targeting so much as the fruits of a collective investigation within the FBI that result in the identification of potential targets, if you will, of electronic surveillance. And frankly, from the Horowitz report, the Horowitz report doesn't fault the government for having conducted that and reached that conclusion. The fault laid within the process that they sought, for which they sought the electronic surveillance.
Well, I looked for a definition of target. It's not in 1801, but it is mentioned in the applications. And if you look at every application, it cites to, I think it's 1823 or something, that the application targets whoever is going to be surveilled. But another question I have for you, and this is why I wish you had the definitions in front of you, is 1801K, the definition of an aggrieved person. And that says it's not just the person who is the target of an electronic surveillance, but any other person whose communications or activities were subject to electronic surveillance. And yet 1810, I believe, limits it just to the targeted, let me see, an aggrieved person.
Your Honor, I don't shy away from the fact that.
Let me just finish. In 1810, an aggrieved person who has been subjected to an electronic surveillance, that's not just the target.
No, it's not.
That's, you know, if I'm under surveillance and I'm talking to my sister, she's subject.
Absolutely.
To, okay, she's an aggrieved person. All right. Well,
and what I also would say, I don't mean to shy away from the word targeting. What I mean to move away from is the fact that there was any one individual targeting somebody, because I think there's negative connotations with that, as opposed to somebody who, because of factual information that was developed, becomes the target of an investigation or the target of electronic surveillance.
Let me ask you about the statute of limitations. You cite Rotella versus Wood for the rule that the accrual clock starts to run when the plaintiff discovers the injury, here the surveillance, not the other elements of the claim. And I mean, frankly, this isn't your fault, but I find the different precedents here really hard to sort of synthesize. So that is a rule, and it seems like under that rule, it's possible that the pleadings place the injury back in the awareness of the injury, the discovery of the injury back in 2017. But then Rotella specifies that claims that involve fraud have a different accrual rule.
So we're not talking about, what we're talking about, the injury here is not fraud. The injury here is unauthorized surveillance.
But I mean, that's where the Richard versus Molesky case comes in. There wasn't a fraud. There was a false allegation about somebody. I mean, there's fraud in the same sense that here there's false or incomplete or wrongful picture put forward, and the wrongfulness of it was not accessible to the plaintiff at the time.
Well, it is interesting here. I think that the facts are closer to Hobson, and I think there's also great analogs being drawn from other Title III cases. But what's important here, Judge, is the fact that he basically laid out in his response, his public response to the Washington Post, his whole outline for this complaint. He basically said everything there that was wrong and how he was wrong in that response. And under Hobson,
well, he knew all along that he was not culpable, but to know that is not inconsistent with thinking, well, law enforcement may have probable cause. It's not.
But that's not what he said.
But they may have that. And so the question is, why don't we assume that that is the reason why Dr. Page didn't sue earlier? Is he's like, I know this is baseless, unjustified, but what could he have pleaded as of 2017 about the defendant's knowledge of the insufficiency of the warrant information?
Because, I mean, if you look at Hobson, this court has found that you don't need to know all the wrongdoers and you don't need to know all the wrongdoing. And what this plaintiff knew was, and what he said he knew, was that the basis for the wire was the Steele dossier that has absolutely no basis in fact. So he had a very good grounds there to do exactly what he later pleaded. I mean, if you look at what he later pleaded, it doesn't really deviate from what he said back in April of 2017. So that's why we think it's on all fours. And in any event, Your Honor, I do think there's another important point with regard to this too, is what we say in many of the Title III cases, I had a very much of a similar reaction. Like, you don't learn an awful lot in those cases. But for instance, in one case that we cite in our brief, the plaintiff sued one person, but it later turned out that the wrongdoer was a private investigator. And she waited for everything to be released. And they said that you could have, even though you thought it was somebody else, you had time to sue. So there was plenty of information that he had here that was available to him that he could have filed and then sought discovery and then got all the information that he needed.
Who could he have sued on April 11th of 2017 when the Washington Post?
I think he could have sued right at that point. Yes, Your Honor.
What?
Yes.
Who could he have sued?
Could he have sued in April of 2000?
Who?
Oh, who could he have sued? Well, first off, he could have started off with the Department of Justice and the FBI. And then subsequently with the discovery, he could have found out more about who it was. And by the way, he also could have gone ahead and sued the FBI director, because under FISA, that's a person who has to authorize their surveillance by statute. Now, the other thing, can
you respond in terms of the time bar to the separate claims that Mr. Scher really focused on, which were the use or disclose claims, and he's made the more nuanced argument that the Dr. Page did not have reason to believe that the information that was obtained through the initial warrant and then the renewals was used in the later ones or disclosed in meetings.
I'll put aside for a moment, Your Honor, that I don't think there's a violation here of use or disclose that was adequately pleaded.
You're referring to the ground the district court used to dismiss?
Beg pardon?
You're referring to the grounds on which the district court dismissed?
Yes.
So bracketing that, assuming that it has been, it would be great to hear your response to this.
I don't think, with regard to the statute of limitations issue on the use or disclose, I mean, first off, it sounded to me in his argument that he's essentially conceding with regard to the first application, that is, that the discovery rule of April 2017 would have begun the clock running. But with regard to the use or disclose, I think that he could have also, those are allegations that, one, he could reasonably have known about because of the fact that there obviously had been a leak to the Washington Post, or one could have assumed as much that the information would have been had to be disclosed. Reasonable inference, because Washington Post is talking about a FISA, and that any allegations with regard to who might have done it or what exactly might have been disclosed could have come later, so after he had the opportunity to conduct discovery. And I'm
How
sorry.
about the use or disclose in the, I guess it is the media one is the, so the use of, in the renewal applications of the prior information, I mean.
Well, I think
Chair
first off,
argues that that you can see how it, not in the initial application, but in the later ones, how there are redactions.
yeah, I think that he's looking, he's moving from, reasonable inferences to complete speculation and conjecture as to whether or not there was FISA information used in each application, and whether or not that would be an improper use. But I also think it's important to point out that, for example, with regard to the Strzok and Page allegations, there simply is there's no allegation that's pleaded here with any sufficiency about what that the fact that any FISA information was disclosed or used. And it's also interesting too, that on one hand, they're arguing that there was no fruits of the investigation, but then that they were using that information for more probable cause.
It doesn't have to be using it for probable cause. It doesn't have to be an improper use. It just has to be intentionally disclosing or using information obtained by electronic surveillance that wasn't authorized.
But there's
And
no,
so even if it's used in a very anodyne way, you know, the warrant application, the renewal application says, tell us what you found so far. And even if it said, well, we listened to him and we found him, you know, coordinating about, you know, dog walking, just if that's all they had found, that would still be in violation, as I understand it, unless you correct me.
well, I think, Your Honor, I think, Your Honor, if it was FISA information, meaning the contents of electronic communications that were recycled through the affidavits, and frankly, there's no sufficient allegation that that was the case. There's no facts supporting that in the complaint. And he's asking for inferences which really go well beyond a reasonable inference to conjecture. And in any event, he mentions information and belief without stating the basis for that information and belief. So it's not adequately alleged under Rule 8 or any standards that this court has applied in the past.
So you're relying on, you're relying exclusively on the ground that the district court relied on. I mean, if you look at paragraphs, I think it's 142, 229, 230. If I disagreed with you that those were, or disagreed with the district court, that those were inadequately concrete, you don't have a separate argument on that.
No, but I think what's the most important thing here is that there isn't any information. There's no basis to conclude that there was FISA information that was used and disclosed. There was no, like, the communications that were intercepted and that were used, and that's FISA information.
It doesn't have to be deceptive. The statute talks about, I mean, I'm just trying to apply this statute where it says that a person is culpable, he intentionally discloses or uses information obtained by electronic surveillance not authorized under FISA. So it doesn't have to be, you know, improperly amping up the probable cause. It doesn't have to be with any particular invidious motive. So if they obtained from the first warrant completely anodyne information, and if you know that the next application, which we do know from the record in this case, that the next applications say, and what has the surveillance to date provided, and you just put in there something that is completely,
If that
just as factual information, doesn't, not to the harm of Dr. Comey, it's not to the further support.
Dr. Page, Mr. Comey.
Pardon?
Yeah, I think you meant to say Dr. Carter.
Dr. Page, I'm sorry.
Dr.
Not
Page.
Mr. Comey, but if it's not to the, you know, smearing him in any way, but if it's just using that information, I guess I'm just asking, like, isn't that A, stating a claim under this provision,
But
and B, adequately alleged?
he hasn't adequately alleged that there or specified what the FISA information was that was used going forward.
He doesn't need to, because there's a place on the form where you have to say what you found, and it was filled in, and it's been redacted. And I mean,
But he's not alleging that. But to go in a different direction, he would just be basically guessing that there was FISA information that was used improperly.
it doesn't have to be used improperly.
No, but FISA information used, and I think that's speculative. I don't think that he hasn't adequately alleged what that was and who used it.
Well, whoever was getting a renewal application was using it. He's alleged that. And whoever was talking about whether to get a renewal,
who is he named that has done that?
the defendants.
No, but without adequate basis to say on information and belief what the information is and really who did it. It's basically speculative as to what his allegations are.
The people who were involved in the decisional chain, reading and approving a warrant application that had a section in it that said, what have you found from the prior surveillance and had text in that, anyone who reads that is using that information in going forward. I mean, maybe that's a wooden
But I
interpretation of
think-
the
I think-
statute, but I'm trying to engage you in helping me.
I'm trying to,
understand how
Judge,
that
but
is-
I think his allegations are essentially conclusory and not sufficiently specific as to who did what.
Do you think even today, any of us know, besides the defendant's name, who actually used or disclosed the information to get the second, third, and fourth warrants?
Well, so I look at two groups of information used or disclosed. First is what the plaintiff was talking about principally on when he was up here a few minutes ago. With regard to Strzok and Page, there's no basis to believe that any FISA information was disclosed. I agree with Judge Pillard where talking about rolling over information into subsequent warrants. I think the question is whether or not that's an improper use, number one. But number two, it wasn't sufficiently alleged as to who disclosed what and whether or not that information was really FISA information. That's what I think one of the weaknesses in his complaint. But in any event,
It
that was
doesn't have to be an improper use. Where do you get improper?
Forgive me, I misspoke. But
That's pretty important.
it is important, Your Honor. But if you used information improperly, would be to disclose it as opposed to just use it. So when I'm talking about disclosing, that would be an improper use.
Well, if you're using it in the course of work, so Mr. Comey, the complaint alleges that he was involved in, he had to sign off on the applications. And
But the certification of that application has nothing to do with the verification of what the facts were.
right, but if one of the sections of the application is labeled information obtained from prior surveillance, then he has used information obtained, and then it's a question of fact whether it was proper or improper.
I think the certification by the director of the FBI is an issue separate and apart from what is the factual basis supporting the affidavit. The certification by the director of the FBI is the purpose to be served by the conduct of the FISA surveillance.
Can I ask you if your reading of 1809 A2 discloses or uses, are you saying we don't know who used it or disclosed it, and that's the problem? It's not concrete enough? Or are you saying disclose or use means outside? In other words, it cannot be used to prosecute somebody inside the FBI who is continuing to use information that was obtained under by unlawful electronic.
Look, I think the latter. The purpose of the disclose and use is outside the government and not within the use of within the application itself.
Well, then how do you ever use this in a case like this where I won't even say a case like this. Hypothetically, you've got an agent who is acting unlawfully by disclosing or using information that he knows was obtained illegally to get further surveillance.
Well, I think in this particular instance, it was ultimately determined that there wasn't sufficient basis for probable cause. So I think that it's hard to answer that question in a vacuum, but I think if there was information that was conjured up or disclosed improperly at some point, it could surface. It's hard to say exactly what that trigger could be, but yes, it could happen, as it did happen here, where review of what happened determination was made that there wasn't sufficient probable cause, and consequently, it was determined to be unauthorized surveillance.
Well, it was determined to be a violation of 1809A2. It may be. That's what that's what we're trying to figure out, is if what happened violated this, and if what happened didn't violate this, I don't know how you could get to a rogue agent.
Well, I don't know that it's any different if you were using it internally with the application either, until at some point, if the government tried to use that surveillance and these applications and so forth saw the light of day.
You, or I don't know if it was you who represented Mr. Comey and the other individual defendants in the district court, but there's a few different pieces of information that are relevant to the time bar issue. One is the Washington Post article. Another is the interactions that Dr. Page had with the Congress. And so his awareness of the facts that ultimately are alleged in his complaint is perhaps more sharply stated in his interactions with Congress. And you had, or the individual defendants had argued in the district court that the statements of the House members about a potpourri of falsehoods and fabricated from the outset were, part of demonstrating Page's awareness. And you don't refer to those in the appellate brief. And I wonder.
Well, I think because I think the interaction with Congress came after the April 17th article. And our point is that the April 2017 article by the Washington Post really was a triggering point for when he should have, under the case law, become aware of the injury. And from that point in time, it's when the statute of limitations should run.
But if you're worried at all about whether he's aware of the knowledge of falsehood, which is it's a key aspect of the claim. The key aspect of the claim is much more sharply stated in saying that these are falsehoods and that they were fabricated as opposed to unjustified. I mean, as I said, you can be innocent, but still have valid probable cause raised to investigate you. I mean,
I don't disagree with you, Judge, because more came out at that hearing than came out from the Washington Post article. So I don't disagree with that.
All right, can you wind it up?
Sure. So the other thing I want to point out too is as we put, I can address the engaged in part of this, but doesn't they have any questions on that? I think that essentially what he's trying to do is have this court legislate where Congress chose not to. And with that in mind, I also would respectfully address the court's attention to our 28J letter, which I know you've seen and reviewed. Unless you have any other questions, that we'll rest on a brief.
Thank you.
May it please the court, Benjamin Schultz on behalf of the government defendants. As the case reaches this court, the claims against the government defendant really reduces to just one thing. It's an 1806 claim for the alleged use within the FISA renewal applications. That claim can be resolved in the government's favor for any of three reasons. First, because the claim is precluded under the statute of limitations. As we explain in our brief, the relevant question is not when he had actual notice of all of the elements of his claim, but just when he had a reasonable opportunity to know that he had a claim. Second, it can be resolved on forfeiture because the entire theory that he presents on appeal, that use of FISA obtained information in renewal applications where the other aspects of the renewal applications contain material falsehoods and omissions is what constitutes an unlawful purpose, is a theory that was never presented in the district court at all. And so under ordinary principles of forfeiture, that argument can no longer be made here. And then finally, it fails on the merits because all of the allegations in the complaint are about how the FISA acquired information didn't tend to bolster the government's case. According to according to Dr. Page, it just tended to show that he wasn't a foreign agent. So whatever unlawful use was being put in the warrant applications, it was the other information that was creating the material omissions and the misinformation. It wasn't the FISA information. So I'll start with the statute of limitations issue, because here there's a couple distinctions with the claim against the government versus the claim against the individual defendants that I want to make sure the court understands. First of all, the relevant date for the government is that he submitted a valid claim is in September 2018. So that means that he has to show that even then, even as of September 2018, he didn't have the information that he needed. And frankly, we just don't see how that's possible, because not only does that bring in the Washington Post article, it brings in his own testimony before the committee, it brings in the committee report as well. And from all of that, he can see that there were not just an initial application, that there were renewal applications. Those gave him information that there was falsehoods in all of that. And for his theory against the government, it doesn't even matter whether he knows whether it was person A or person B. He just has to know that it was the government, and he knew that. So then really the only thing he's left with is the argument that he's presenting today, that he says, well, maybe we knew that there were falsehoods, but we didn't know that there was FISA acquired information in the applications. And that's actually precluded by his own admissions in the district court. And so if you go to page 209 of the joint appendix, this is his opposition to the government's motion to dismiss. He says, he acknowledges that what's in the renewal application hasn't been publicly disclosed, but he says that doesn't matter, because it's logical and plausible to conclude that because there were four successive warrants issued by the FISC, the applications for the 3 follow-on warrants included information obtained unlawfully through the preceding warrants. So he's telling you quite clearly that he could, at the very least, reasonably conclude and infer from the fact that there were renewal applications, that those renewal applications would have contained FISA-acquired information. And so at that point, once he knew that there were renewal applications, he should have brought the claim. I'd be happy to address that further. I think that can adequately resolve the case. But just briefly on the waiver.
And on the statute of limitations, there's some argument about whether there's a 6-month and a 2-year, and do they both apply?
So basically, these are the same procedures as are used under the Federal Tort Claims Act. You first have to submit an administrative claim. You have, it's a 2-year period to submit that administrative claim from when the claim accrues. Once you submit the administrative claim, if the government denies the claim, and it denied it here, then you have 6 months from the denial to bring a suit. So we're not saying he missed the 6-month bar. The bar that's relevant here is the 2-year bar.
And why isn't Page's claim similar to that of Richards and Richards versus Molesky, where we held that the plaintiff's claims were told until he discovered that not just that, I mean, he knew from the beginning that he was innocent of the charges that were being alleged against him, but we held that he didn't have to sue until he discovered that the defendants had intentionally lied on that they had a confidential source.
So respectfully, Your Honor, there's a couple responses. The first is that at least after the congressional report was released, if not sooner, he knew that there were misrepresentations. I mean, the report, you can find this on JA 106, page 106 of the Joint Appendix. It says material and relevant information was omitted, including from the renewals, and it talks about the Steele dossier. And he's already previously said, before that committee report was released, that he thought the Steele dossier was complete fabrication. So at that point, he surely knew that there were lies. In addition, though, I think the relevant question here is the terms of the statute that talks about claim accrual, and this is 18 USC 2712B. The claim shall accrue on the date upon which the claimant first had a reasonable opportunity to discover the violation. It's not that he has to know every single fact. It's just that he has to have a reasonable opportunity. And given that he himself was saying that he thought that there was falsification and that there were a congressional report released that tended to support his theory, and given that he himself is saying that once he knew that there were renewal applications, it was logical and reasonable to conclude that there was going to be FISA acquired information in those applications, then we think he more than met the standard. And in this regard, Your Honor, I'll just, we cited the Sprint Communications case in our brief, which is a case from this court, and that talks about claim accrual, and it talked about how when somebody had, there was information that somebody was engaged in a particular kind of malfeasance in 1981 with their pricing practices, and this court said, well, even though you didn't know that that malfeasance was going on with regard to different rates that were being set in 1984 and 1985, you could reasonably infer that the illegal stuff that was going on in 1981 would have continued in 1984 and 1985, and that logical inference is sufficient to accrue your claim. So if a logical inference based on one piece of information was sufficient to show that 4 years later you had a claim based on different acts, in that case, we think that would also cover this kind of
Is that at the
situation.
motion to dismiss stage?
So Sprint Communications was actually an agency review case. But again, I think the only relevance that the motion to dismiss has here is what are the facts that the court has to decide based on. Here, if you look at the facts that are alleged in the complaint and you look at the facts that are incorporated by reference into the complaint, you have everything you need. And here, I think his own admission in the district court is the coup de grace, if you will, because he's saying that that was enough for him to conclude that the renewal applications contained FISA required information. And I'd be happy to address the other arguments that we have about.
We have your brief. We have your brief.
Thank you, Your Honor.
Only, Mr. Sheriff, take 2 minutes, but that's it. Unless there are questions.
Thank you, Your Honor. Just a couple of points in response. First of all, with respect to the statute of limitations, it is an affirmative defense. The defendants have not answered yet, and the arguments that they've made are a perfectly fine summary judgment argument, but not a proper basis for dismissal based on the statute of limitations. And as to the case law, the case law, it seems to me, overwhelmingly supports Dr. Page's position here. The Richards case that we've discussed earlier, the Rotella case also, and then if we look at if we think back to your conversation, Judge Henderson, with counsel about 1801, what was it, 1801A, the issue of the targeting. Well, Mr. Kelly said that no individual and no group was actually targeting Carter Page. Well, if that's true, then the surveillance was entirely unlawful because the statute requires that somebody be targeted. And so they were obviously targeting Mr. Page, and and what they did, and especially their use and disclosure of the subsequently acquired information is patently unlawful, we think. Now, Mr. Kelly also talked a lot about the uncertainty as to who exactly did what. And to the extent that's an issue, we have John Doe plaintiffs in our case. And so it seems to me that would solve that problem. And just by way of conclusion, as Judge Henderson pointed out, if what is alleged here doesn't constitute a violation of 1809, it's hard to imagine how you would ever hold a rogue FBI agent accountable. And we urge the court to reverse the dismissal.
Thank you.
The Honorable Court has done Tuesday, December 10th, 9:30 a.m.